Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below as well. Internet, please don't fail me now. Please don't fail me now. Come on, we're trying to go live here. Hang on a second. Let me know in the chat if you guys can see and hear me, or if I'm frozen or what, because this is really frustrating. Oh gosh, come on. Okay. All right, am I live? I'm back. Out of lip sync. I'm fine. Okay. So okay. You can hear me. You can see and hear me. Okay, good. Here we go. So we do have a court feed that just got up. We're going to start from the beginning, even though it starts kind of out of nowhere. But we've got in what looks like an opening statement here from it's got to be the state, because they have the burden here during this hearing. But we'll start real quick with a brief intro. There's information in the description of the video about this hearing and about, hi Holmes, hi buddy, about the hearing and about the case in general. It's kind of a wild case. This is basically TLDR. This is going to be like a mini trial, and it might actually supplant the trial completely. So because of the fact that, number one, if the defense prevails today, their case is dismissed. Number two, if the prosecution prevails today, the defense might decide to strike a deal. So that might be reason why this doesn't end up going to trial one way or another. So it's going to be really interesting. The state has the burden today, but the burden is clear and convincing evidence, not beyond reasonable doubt. So lower than beyond reasonable doubt, but higher than preponderance of the evidence. So higher than a civil case. Holmes is running around and shouting and making sure that everybody can hear him. Okay. All right, let's get started with the hearing then, and we'll just jump right in from where we are able to start this feed. Let's go. And I was trying to get in the IndyCam set up as well, because you can see she's here on the couch here, or on the chair here, but we'll see. I might fidget with it while we're watching the hearing as well.
Field, the force used.
Let me know if you can hear it. Okay.
So to that end, as the court is aware, we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force
Thank you, Andy, the game maker.
Was not justified.
Unfortunately,
that's what the statute says, and that's what the case law holds. The standard that state has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a stand your ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the cite at 292 Southern 3rd, 471, and specifically page 483, second DCA case 2020. The court there pretty much stated that the inquiry for the court is to entertain any evidence which establishes that the force that was used was not justified, which means, Judge White, that any other inquiries are irrelevant, specifically motive. Motive, a lot of times at a trial, is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them. But the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the stand your ground statute's requirements. As the court knows, the issue is, was Ms. Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm?
That's the kicker here. Objectively reasonable fear.
Supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on stand your ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins versus State, which is in our brief. It's at 344 Southern 3rd, 625, page 626. Also a second DCA case in 2022. Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court, also in our motion, the case of Jefferson versus State, 264 Southern 3rd, 1019. Again, a second DCA case, 2018. Here's what the Jefferson court had to say in upholding the stand your ground motion and immunity filed by the defense. Quote, "We are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032, subsection 4, stand your ground." In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir. All right, State.
Okay. So yeah, that was actually the defense.
Benefield.
Now we're going to hear from the state.
Judge, I suppose now we're into our omnibus motion.
Ooh, someone's alarm is going off.
And you're talking about your omnibus motion?
Yes, sir.
Under, hold on one second. I'm looking through. Do you want to go ahead and put whatever it is on the record related to
Yes,
Tommy
sir.
Benefield?
Number 2, yeah.
Number 2.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about testimony by non-expert witnesses who lacked personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the absolute right to open the door or keep it closed as it relates to character evidence. Only the accused can inject character evidence, after which the state is permitted to rebut it. It is the same thing with a witness's testimony under 90-404, Your Honor. Mr. Benefield is limited. The state can establish that Douglas Benefield had a reputation for peacefulness once it's attacked. The rule is very clear. So it has yet to be attacked. Mr. Benefield can only testify as it relates to the rehabilitation of character by the state for peacefulness to his reputation in the community. Mr. Benefield did not live here in this community.
What they're
He can
referring to
only
is the brother of the
testify to his
decedent
personal
or the alleged victim.
perception of his cousin's
He's supposed to testify
reputation
about his
for
brother,
peacefulness,
apparently.
which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is I heard your objection. I'm going to reserve on it because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it and I'll reserve at the end so keep making your objections. I'm going to reserve on those, at least this one.
Understood.
Some of them might be a more clear call, but we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you. But let me say this. Having sat on at both tables, you make every single objection as we go that you feel you need to make. But I understand completely you have just a general objection to all of that character evidence, the background. You want to focus on that particular.
So
day.
her allegation here is that
Yes,
he
ma'am.
was psychologically
Okay, thank you.
abusive, that he was also even trying to poison her while she was pregnant with their child, that they got pretty quickly pregnant and married 2 weeks after they met. So she made a number of allegations here about him basically trying to kill her or being psychologically abusive. So obviously the state has an interest in showing
solemnly swear or affirm
he wasn't
testimony you're about
abusive.
to give in this case
he was
to be the
peaceful.
truth, the
He
whole
was,
truth,
you
and
know,
nothing but the truth.
your average person just trying to fight for the custody of his kid after they were, you know, separating.
Stay about 12 inches from the microphone, please.
Hello, sir.
Morning, Judge.
My name is Judge White. I'm presiding over this hearing. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It adjusts up, down, left, right, wherever you're comfortable. If you just speak in a loud, clear voice, it'll pick everything up.
Yes, sir.
Good morning.
Good morning.
Let me just ask, can you see?
I can, Your Honor, it's being blocked a little bit by the court.
If you need to readjust yourself or reposition, please feel free to do so. Yes, ma'am. I'm sorry.
Please state your name.
Tommy Douglas Benefield, Jr.,
How do you spell your names?
TOMMIEDOUGLAS BENEFIELD JR for
So
Junior.
this is the
And
brother.
What was your relationship to the deceased Doug Benefield?
First cousins.
Oh, cousin.
And how
Sorry.
close were you?
We were close our entire lives, and I was instrumental in him going into the Navy. When I was in the Navy, both naval officers, both flying off aircraft carriers, both did other work for the government. And then all the way through his business career and his dual career in the government and in private, probably talked weekly to monthly, depending upon the times of our lives.
Okay.
I visited his family multiple times in Charleston.
And let me just ask,
yes, ma'am.
before he died, where did he live?
Well, he was in an apartment down here at the very end.
But before he moved to Florida, where did he live?
Charleston, South Carolina, 701 Preservation Place.
And where do you live now?
I split time between Jacksonville, Florida, and Atlanta, Georgia. My wife and I have a spa business in Atlanta, Georgia, and I work 2 weeks a month in Honolulu, Hawaii.
And what is your job?
I'm a flight instructor for Hawaiian Airlines, teaching pilots in a particular airplane.
So let me ask you a little bit about Doug. At the time that he was murdered, how old was he?
He was just 1 week short of 59. He's born October 5th, 1961.
And how tall was Doug?
5'9", 5'10".
Okay,
How much did he weigh?
not that tall.
I'd say 160 to 170.
And you already said before he moved to Florida, he lived near Charleston, South Carolina?
In Mount Pleasant, a suburb on the north side of the river.
Okay, and just before he moved down here to Florida, who did he live with in the house?
Just Eva and himself, except for the time that Ashley was living there previously.
So you said Eva. Who's Eva?
Eva is his biological daughter, first daughter, with his longtime wife, Renee.
And how old was Eva at around this time?
15, I believe.
So a teenager.
Yes, ma'am.
When did you first meet Ashley?
I had an overnight. I was flying for Southwest Airlines, had a change in a schedule. They sent me to Charleston, just me, not the rest of the crew, to take a plane into Charleston. And I texted Doug and said, hey, I'm going to be in Charleston tonight. Let's go to dinner. He texted back, great. April 14th, 2017 was the date.
You seem to remember dates well.
I have a very good memory, ma'am.
Okay. So you remember the exact date was April 14th?
Yes, ma'am. And I keep a diary and a flight log, so I know exactly when it was.
So did you in fact meet up with Doug?
Yes, when I got into Charleston, ahead of the hotel, I texted Doug again, and he said, Ashley's not feeling well. Could you take Uber up to Mount Pleasant to the house?
Overruled.
Did you know who Ashley was?
I had never heard of Ashley at that time.
So he spoke it like you knew who she was.
Yes, ma'am.
Did you take an Uber to their house?
Yes, ma'am.
Once you got to the house, did you meet Doug
I met Doug and Ashley together.
and Ashley? Was that the first time you'd ever met the defendant?
Yes, ma'am.
Did you speak with both of them together about their relationship and how they met? I'm assuming you were basically like, who are you?
We spent 4 hours together.
Okay.
We started at the house. I got her short life story, their life story together at that time.
So their life story together at that time, did they say how long they had known each other before they got married?
Yes, ma'am. It was almost a sense of pride for both of them that they had only known each other 13 days.
13
And
days.
How old was Ashley at the
It's
time?
a short period of time.
At that time, Doug was 54 and she was 24, I believe.
So a 30-year difference.
Yes, ma'am.
Between them. And I think you already answered this earlier, but did Eva live in the house with the two of them?
I don't think so.
Yes, she did.
Oh, she did.
Did the defendant ever mention that she had a job?
No, ma'am. It was only past history stuff and what she was doing temporarily in the 2016 timeframe.
Was she interested in the ballet?
Yes, ma'am. She was a former ballet dancer. And by this time, they talked about the American National Ballet they had founded in February.
So let me stop you
Yes,
there.
ma'am.
So was Doug interested in the ballet?
The way a husband is, proud of his wife, supportive. Knew nothing about the ballet except its existence, I think, prior to that.
And prior to this meeting with Ashley and all this, had he ever expressed any interest in the ballet?
No, ma'am.
So you mentioned February. So they started a ballet in February?
So there's an old ballet that was defunct called the American National Ballet. When Ashley wanted to start a ballet and make this a special ballet, a diverse, non-judgmental, non-stereotyping ballet, Doug found a name and found an old ballet, and that's, I believe, February 27th of 2017 is when they founded it on paper.
So a couple of months
I'm
before
sorry,
you met.
Suzanne. Continuing relevancy objection. I don't want to keep interrupting.
Understood.
So you mentioned that was February of 17. So that was roughly 2 months.
Yes, ma'am.
before You met Ashley. And how was the ballet being paid for? Did they discuss that with you?
Doug did. They both did.
Okay.
Uh,
Ashley did as well.
She talked about it.
Yes.
She understood what Doug was having to do to raise money and to put money personally into it. Doug was very, very good in all his businesses about doing the founding paperwork and establishing an LLC. And he had done the same with the ballet. He had built a website, just typical of Doug to build it all himself from scratch.
And you said he put his money into it.
I know he put his money all the way till he ran out.
And then did he also have other money?
There were investors, including his business partners and other donors through the process. Yes, ma'am.
Okay. So it was actually formed in February of 17, but was there a formal launch of the
So
ballet?
the night I spent with them, they talked about the upcoming events. There was an informal launch in May. There was a formal big donor party that I was a part of, brought all my business partners, a lot of veterans that I work with, to a McKee House event in August, I believe 12th of 2017. So that's the ballet that I learned when the event was coming out, and planned on being there and bringing all my people.
Okay. During this time, 2017, at some point, did Ashley and Doug decide that they were going to have a child or try to have a child?
That wasn't a part of that first meeting night. We talked about everything else and caught up on everything that we hadn't known. But it wasn't a part of that night. We ended up leaving the house, going back to my hotel, having dinner together. I'm a master trainer in a medical device. It's a pain relief device. It helped her, helped him. And then they headed back home that evening, but there wasn't any talk that evening about having a child.
Was there talk later on specifically with the defendant about the child?
Certainly. Vasectomy reversal is a very intrusive surgery for men. And when they made the decision they were going to do that, he and I talked about it at the time, in particular because of my medical device background, that could help him.
So they decided as a couple that they were going to have this vasectomy reversal to try and have a child.
Yes, ma'am.
And did the defendant in fact get pregnant that year?
He had the vasectomy reversal, and 3 months later she got pregnant. I believe, because we talked about it later, that the conception date was July 10th of 2017.
And at some point shortly after that, did she move away from their home in South Carolina?
Yes, so August 12th is when we had the McKee House event, the big donor event, introducing the other members of the staff of the ballet and everyone involved. Ashley and her mother, Alicia, were there. I was there. And 2 weeks later, I believe on the 26th or 27th, they made the decision together that it would be better for her because of her morning sickness to go live with her mother because Doug traveled for work and was busy, and that was what was presented to me by both of them.
And her mother lived in
Lakewood Village here in the Sarasota-Bradenton area.
Florida.
Yes, ma'am.
And so shortly after that, did Ashley move?
I believe on the 27th of August, because Doug called me both on the way down and the way back.
Did he help her move?
Oh, yes, ma'am.
Did he move with her?
No, ma'am.
That
He
is kind of
stayed in South
strange.
Carolina?
Yes, ma'am.
That is a little strange. I'm not going to lie.
So that was August.
There are
of 17.
circumstances where
Did
that can be
the
explainable, but
ballet eventually go under?
at first blush,
And when?
it's not expected.
So the ballet opening.
So far, there's been a lot of things that aren't expected, though, to be
the
fair.
actual launch to the public was September 18th of 2017. That's a landmark date in this case in my history because it's the date Ashley and her mother went back in the house and got her stuff, and she filed against him.
Okay, we're not
I'm
going to talk
sorry.
about all of that.
I'm sorry.
So shortly after this whole time, we're going to skip ahead, did the ballet eventually collapse completely?
Yes, ma'am. I'll answer it more directly. I apologize.
That's okay.
So they launched it publicly on September 18th. The biggest performing arts center in Charleston is called the Gaillard Center, Big Performing Arts Center. And they actually held an opening performance on December 7th of 2017. And the dancers had been paid through December 15th.
Uh-oh.
And by the end of the month, everything was finished.
Okay,
Wow.
so by the end of December 2017,
Everything's done.
it was defunct.
Yes, ma'am.
Whoa. That's very short.
During the time that you encountered Doug and Ashley together and talking to Doug, how did he act about Ashley?
He was completely in love, completely supportive, starstruck, visibly, physically. You could tell by the way he treated her, took care of her on the opening night that I met him, met her, and then it continued through the entire relationship until I never saw them together after the separation.
And when was that?
Thank you, Megan Hunter, RRT.
Well,
That's interesting.
physically, August 27th of
We'll probably hear about
2017,
this.
when he drove her down.
So you never saw them together after that you can remember?
Well, I'll leave a caveat on that. I spent a weekend down here with Doug, Ashley, her mother, spent one night in the home where Doug was killed or murdered. And I don't remember that date. It could have been after the separation, probably was, but I just don't remember that date. But that would have been the only time that I saw them together after that August 27th period.
Thank you. I have no other questions. The defense will probably have
Okay.
some questions. Thank you.
Cross?
Thank you, Judge.
And let me just say, I completely understand that based on my evidentiary ruling so far, how do I say this? I know you probably wouldn't have asked a bunch of questions, but certainly for your cross-examination and any proffers of cross, I understand it's going to be broader than what it might have been.
Maybe not.
All right, maybe not. And please, sir, feel free you can question from either podium, wherever you feel more comfortable.
One thing that's interesting is you're probably going to see fewer theatrics here because it's not in front of a jury. It's in front of the judge. The judge is going to be making the determination on this.
Good morning, Mr. Benefield. I'm Neil Taylor. I'm appearing on behalf of Ashley Benefield. I regret that I meet you under these circumstances.
I understand, Mr. Taylor. Thank you.
You were a pilot,
Yes, sir, still am.
and consistent with being a pilot and listening to you and your detailing of events and dates and times, it's pretty stereotypical of the discipline that a pilot generally brings to their profession. Would you agree?
Yes, sir. You want the best people up front that work like I do.
All right, and you've told us that as a first cousin, you were very close with Doug Benefield.
Yes, sir. I was closer with Doug in our adult lives than my own brother, who was still alive at that time.
All right. Now, Doug was not a pilot.
Yes, sir, he was.
A commercial pilot?
No, sir, a Navy pilot.
Okay, not a aviator, not like the second seat.
Genergy, this
The
is Ashley's
actual
lawyer.
pilot.
Yes, the defense
So
attorney.
in a multi-crew
You're on
plane that he
cross-examination
flew, the
now.
S-3 Viking,
Yes, sir.
he started out as a naval flight officer out of training. And then he became a second in command, which is like the first officer in the airline world, actually at the controls. And that's how he finished his flying career in that airplane. So he flew the plane, he flew in the front of the plane, and not always in that position.
Okay. Now, being as close as you were to him, you were aware, were you not, that he was an accomplished, among other things, martial artist?
I never saw that personally.
Were you aware of it?
I knew that he was a wrestler in high school.
Actually, he was on the judo team in high school, was he not?
Well, he was a state all-star wrestler, which is I'm very aware of, but I was not aware of the martial arts being a part of it.
So as close as you were, he never spoke to you about his accomplishments on the high school judo team
No, sir, more about the wrestling.
or his training in the military for martial arts.
He had the same training. The military doesn't train in martial arts.
Did he
It's pretty
confide
basic.
in you the training that he went through once he left the service through the private sector in conjunction with servicemen, both active and retired?
Not specifically, because we don't talk about that stuff if we're in really special programs.
Okay. Tell us about the physical condition Doug Benefield was in. He was built pretty well, was he not?
He was in terrible condition the night I met Ashley. He was in pain from his ejection from an airplane in the Navy that led to back surgery that year in 2017. He was not in good condition at that time. He became in good condition after he bought the device that I am a master trainer in, and it brought him back to health.
Yeah.
He was in very good condition when he was regularly going to the CrossFit. I'm sorry, I don't mean CrossFit. Some fitness facility called Iron Tribe, which is a Christian-based workout facility. And I believe the last pictures of him on Facebook are in that gym. He was in very good shape at the end.
You saw the pictures?
Yes, sir, I've seen the pictures.
Okay. And they accurately depict the shape that he was in at the time of his demise?
Yes, sir.
Now, you've told us that he was, I think the words that you used.
Shireen, thank you
Mr.
so much for
Benefield
gifting
was
One Legal Bites
starstruck,
membership. Thank you. And Arta
with my
Rissanen,
client,
welcome back to
Ms.
Fight Club.
Benefield.
Yes, sir, I would say that.
You're married,
Yes, sir.
happily so.
Very happy.
How many years?
Just over 4.
All right. Do you own a weapon, a firearm?
Objection relevant.
I'll overrule.
I own firearms, but I do not have a concealed carry permit like they did.
All right, and you're familiar with firearms from your time in the Navy, I trust.
Less from the Navy than after.
Okay. Have you ever fired a firearm inside your home? Intentionally?
Oh,
Not intentionally or unintentionally.
Did your cousin Doug ever tell you that he admitted to firing?
Objection, Judge. This is part of what we were not going to get into.
oh,
So the objection is relevance?
The objection is relevance and that there were certain complaints against that this defendant made against the victim that were denied by Judge Moreland in a hearing, and this is one of those.
Okay. So is there a written agreement not to get into this and that written agreement delineates everything,
No,
or
but
is this?
I thought we were not going to get into the specifics about it, other than it was shooting into the ceiling.
Yeah,
Oh.
well, I intend to stay within the four corners of my motion, but I think it's fair cross-examination based on what he's testified to, his intimate knowledge of Douglas Benefield.
Okay. I don't know. I don't know what the agreement was to get into or not get into. I don't know what the relevance of this is going to be. It may be relevant, it may not. But again, I don't have to unring a bell with a jury here. So for now, I'll allow it.
Thank you.
I may decide later it's completely irrelevant. I don't know.
Okay. So there's some kind of details around
Yes.
him shooting a gun
Have
inside
you
the
ever
home
fired a firearm inside your home?
that the
intentionally?
prosecution doesn't want in.
Have you ever considered firing a firearm?
probably highly
inside your
prejudicial.
home intentionally to intimidate your wife?
Objection.
Whoa.
Of this question.
Hold on, let the question finish. Let the question finish. Go ahead. But
Thank you.
sir, hold on. There's going to be an objection.
Yes, sir.
Go ahead and finish your question.
To intimidate your wife into not speaking any further.
Go
And
ahead.
what is the relevance of whether?
I
he
just
has
need
done that?
objection relevance,
Relevance.
sustained.
Yeah, that's definitely
Did
not relevant.
your cousin
But the
ever
reason why he's
share
trying to
that with you?
have him answers to be like,
My
Objection
cousin,
hearsay.
Overruled.
my cousin admitted both privately.
Is the answer yes?
I would like to answer your question and be very accurate, sir, like I've been all along.
I understand, however, Mr. Benefield, this is
Yes, sir.
cross-examination.
Yes, sir. He inadvertently fired a gun in his home.
No, he testified under oath that he intentionally fired.
Objection, is there a question?
Improper impeachment. Go ahead, sir.
Did
Sustained.
he ever acknowledge to you that he intentionally fired? the
No,
weapon?
sir, he did not.
Did
Woo.
he ever tell you
this is
that
some good
he
lawyering,
threw
though, I've got to
a
say.
loaded gun at Ms. Benefield?
Perhaps we talked about that. I don't remember that specific event like I remember the inadvertent firing.
He's maintaining it's inadvertent. Defense is trying to suggest that he
ever
did that to
acknowledge you
intimidate
that he
her.
Punched the dog in the face
Oh.
so hard that it rendered the dog unconscious.
Oh my God.
That's not what happened in his story to me.
Were you there?
No, sir. You asked me if I talked to him.
Did he ever acknowledge to you that he punched the dog in the face so hard that it knocked the dog out?
He admitted hurting the dog, but that's not a detail I remember.
Is the
Oh.
answer to my question no
Oh,
or yes?
Would you restate the question, please?
Did he ever admit to you punching the dog in the face so hard that it knocked the dog unconscious?
No, sir.
Did he ever tell you that he regularly carried a loaded firearm?
Of course.
All right. And to be clear, it was a firearm that was also cocked. All that was necessary was to pull the trigger.
I don't remember that detail, but I'm sure that he carried it appropriately or he wouldn't have carried it.
Okay. You don't know whether he carried it wrapped or not?
No, sir.
Did he acknowledge to you that he placed a tracker on Miss Benefield's car?
No, sir.
Did he acknowledge to you that he was caught at night by a neighbor peering into
Objection,
Miss?
Judge. Counsel is testifying just to find out if this witness has the information.
Correct.
If he
So-
wants to call a witness, fine.
Your Honor, he's testified.
Hold on. The way cross-examination works.
Yes, sir.
Is that the attorney is allowed to ask his question.
Yes, sir.
Generally, it's going to be yes or no. If you can agree with it, you agree with it, and then you agree with it in total,
Or not.
or no.
Yes, sir.
And if it's a question about, do you know, you know or you don't.
Yes, sir.
And state, I understand what you're saying on the counsel's testifying. That's another issue, obviously, if there was a jury here and so forth. With me, I'm not going to be influenced by the question. The witness can say, yes, that's true, or no, it's not. I know that. I don't know that. So go ahead.
Thank you, Judge. Did he admit to you and acknowledge that he was caught by a neighbor of Miss Benefield's at night, standing in the neighbor's yard, peering into Miss Benefield's window?
I don't remember that from him.
Is that something that you think you'd recall?
Yes, sir.
Is that something that you would expect of the Douglas Benefield that you knew as well as you did?
It's a possibility, not a regular habit of his.
Did he acknowledge to you, Mr. Benefield, punching holes in the drywall of their home out of anger?
I'm aware of one, not many.
And finally, did he acknowledge to you beating up his first wife, Renee, on their honeymoon?
I'm not aware of that.
Jeez. These are some allegations.
When he lived here in Bradenton, Mr. Benefield, I want to be clear about something. At no time, to your knowledge, did he live in the same residence as Miss Benefield?
I know that they were on the lease together in the final apartment, but I don't know if they ever were in the apartment together, but they were on the lease together.
Okay, so my question to you is, did he reside in a separate apartment here in Bradenton?
He had an apartment in Bradenton. Yes, sir.
I don't believe I have anything further.
Yes, sir. Redirect.
Yeah. Yeah. Let's see how much the defense or the state is going to
Yes,
clean
I
this
was
up.
going to say, if you need a moment, go ahead and
Yes.
do that. Hold on one second.
Because the part about the punching of the dog, he said that he had admitted to hurting the dog, but whether that was intentional or not was not clear in cross-examination. Definitely very emotional. You know, if this does go to trial, that's something that will affect people on a jury. You can see it in the chat. It affects me personally as a dog lover. But let's see, cross-examination. A good cross-examination is going to score some points. Redirect can actually bring some of that back. So let's see.
To consider at a later time.
Remember, these are whether he knew about, whether these allegations existed or whether he knew from Doug that these things happened. And so the implication, of course, is there that these things happened, but you can't get that much out of this witness because he wasn't there for these alleged things to have happened.
Move into evidence any testimony of the witness referred to, the non-testifying party, that exists. So in other words, during the state's examination of Mr. Benefield, wherein hearsay statements were allowed, the defense is entitled under 806 to move into evidence the entire statements of any prior statements made by Mr. Benefield, the deceased. If the court would take a look at that rule, I'll address it later on.
Okay, so the doctrine of completeness.
Just so you guys know, I am
The
saving
doctrine of
questions
completeness?
in the chat, so to bring them up when we have a moment. So if you guys do have questions and I'm not responding to them, I'm more than likely saving them to answer them later, just so you guys know.
The hearsay statement in any capacity or any statement of the non-testifying witness may be admitted into evidence by the adverse side.
I guess it'll just depend on what the statement is and when it was made and the relevance, and sure.
Yes, I'll address it with the court at a later.
Okay. Yes, ma'am, redirect.
Just for the record, Judge, I completely disagree that that's what 9806 says. And in my direct examination of Mr. Benefield, I was very specific to only get Ashley's comments, not Doug Benefield's comments with reference to hearsay. So just that will be my response to that. So the defense asked you about this punching a dog issue.
Yeah.
Yes, sir. Yes, ma'am.
And you said that's not the story I got. What was the story you got?
The story I got was that Doug was sitting on one of his chairs with an ottoman. He always wore short shorts, bare-legged sandals, just like the night he was killed. And the dog jumped up in his lap because the dog was I picked up the dog after his killing, so I'm very familiar with Sully. Big dog, big nails, jumped up in his lap. And he was frustrated and it hurt. Aggressively pushed is one way, is what he told me.
Okay.
He admitted that was more than he wanted to do to the dog, but it was due to his frustration at the time. He pushed the dog off of his lap because it was cutting into his legs.
So at no time did he say he punched a dog?
No, ma'am.
At no time did he say that the dog went unconscious?
No, ma'am.
And the defense asked you if you were aware if Doug told you that he put a tracker on the defendant's car. Were you aware of that?
No, ma'am.
Okay.
I think the dog
The
is
defense
a
also asked
golden
if
retriever.
You knew about Doug punching a hole in the wall.
I knew about one punch.
And what was the reason for that punch?
Frustration.
The defense asked you if Doug regularly carried a firearm. Did Ashley regularly carry a firearm?
Even the first night she met him in front of Secret Service in the area. Yes, ma'am.
So did she have a concealed weapons permit?
I understand she does.
And did Doug have a concealed weapons?
Yes, ma'am.
No further questions.
All right. Did you have any further questions before we let this witness go?
Yes, one. Mr. Benefield, where did you obtain the explanation about what happened to Sully by your cousin?
Both from Ashley and Doug.
Okay.
Your Honor, now, again, I would direct the court's attention to 806. And briefly, if I may, Your Honor, I'll read to the court why I believe it's appropriate. Attacking and supporting credibility of declarant. When a hearsay statement has been admitted in evidence, credibility of the declarant may be attacked, and if attacked, may be supported by any evidence that would be admissible for those purposes if the declarant had testified as a witness. Evidence of a statement or conduct by the declarant at any time inconsistent with the declarant's hearsay statement is admissible, regardless of whether or not the declarant has been afforded an opportunity to deny or explain. Okay, so I think any statement inconsistent with this witness's repetition of a hearsay statement by Douglas Benefield is admissible. And I would suggest that the exhibits to our stand your ground motion clearly apply to that.
I don't know which exhibits we're talking about.
I don't either. And Judge, I would argue that the only person that elicited hearsay was defense counsel. So defense counsel cannot elicit hearsay and then try to impeach the hearsay that he elicited. So I would object and disagree with that.
Yeah, I don't know what are we?
Judge, Your Honor may recall that during the direct examination by Ms. O'Donnell, Mr. Benefield related conversations that took place with the deceased, Douglas Benefield. And specifically, there was a hearsay objection. The court overruled it and allowed it. That opens the door to 806, Your Honor.
Right, I didn't hear argument on it. Which specific statement was it?
I believe, among other things, Mr. Benefield testified to everything relating to the ballet. I believe he testified to statements about how enamored Douglas Benefield, the deceased, was with Ashley Benefield. Those hearsay statements alone, Your Honor, open the door to 806, so that any statement by Douglas Benefield that is inconsistent with that testimony is admissible.
I don't remember any statements where, you know what, this would probably be better, sir. We're talking about your testimony.
It's okay.
I'm going to excuse you to the
Yes, sir.
hallway.
No worries.
The rule of sequestration has been invoked.
Yes, sir.
That's a rule here in the state of Florida, probably other places too. That says once you're called as a witness, your summons as a witness, you're not to discuss your testimony, the questions asked, the answers given with anyone at all until you're released from your subpoena or the hearing or the proceeding is concluded.
Yes, sir.
So that rule has been invoked. So when you're outside, you can't talk to anybody.
Yes, sir. I understand the rule and I'll follow it.
All right, thank you, sir.
Sure.
We'll call you back in as soon as we can.
Yes, sir.
Yeah, Christian Williams asking, do you think
All right, the
Ashley
witness
Benefield will
has stepped
testify?
out.
Yes, I think
On
so.
that
I think she's going to
particular,
have to, because there's a lot that they are
point,
arguing from that just
I
comes from her.
got some
So if they're going
pretty
to really
decent
make their
notes, and I
case
was
here, I think she's going to
listening.
have to testify.
My notes are not that he
Most likely.
said that,
In my
just that
opinion.
he observed that Mr. Benefield was starstruck. I mean, nobody clarified, how do you know that? Did he say
Sasha
it?
Ten Hag,
Was it
welcome
your
to the Bike Club.
observations?
Thanks for becoming a
So,
YouTube
I
YouTube
don't think that's
member.
necessarily
I
a
can talk.
statement. What other
Thank
statement
you
in
so
particular?
much.
There's one
Thank
I
you so much for
overruled.
supporting the channel.
I didn't see it as being offered with the truth of the matter asserted, so I didn't see it as hearsay.
Sure.
I know there was one of
understood.
those.
My objection was on the basis of hearsay.
Mhm.
The court allowed it. And I think if you will, the danger of 806 and why it's can be a two-edged sword is that it does not restrict the subsequent admission to anything relevant to the hearsay statement that is allowed. It rather sets up the credibility issue. And once a hearsay statement is allowed into evidence, then any other statement that the declarant made that is not available is admissible if the credibility of the declarant is being attacked. So, for example, on cross-examination, I questioned the witness about these violent acts by the deceased. Some he acknowledges were told to him, some he denies were told to him. If I have an admission, even though it's in a hearsay statement, if I have an admission by the declarant, it is at that point admissible according to 806 in evidence. It doesn't make a difference that the hearsay statement, Judge White, is related to the hearsay that the court admits.
So you're saying if one hearsay statement is let in, whether, and let me also say, somebody might object to hearsay, overruled doesn't tell you if I overruled because I don't see it as hearsay. It was a statement, but it wasn't offered for the truth. Could be that I went through the catalog of exceptions and found as one of those. So I wouldn't read too much into overruling a hearsay objection.
Sure, and I understand.
And 806, familiar with it, and it's when a hearsay statement is put before the trier of fact or into evidence, that the hearsay declarant's credibility can be attacked or supported as allowed by the rules. I don't think it kicks open the door to any possible hearsay statement the declarant ever made on any topic at all.
Respectfully, if it goes to the declarant's credibility, I would say it does. And I think that the statute and the case law will support that because again,
When he's
it's
referring
not
to
tied
declarant,
to
he's
the
referring
I
to the
didn't say
person that made
credibility.
the statement that is
I
being
said-
brought in.
Any hearsay statement. That's what I'm hearing, is that we can bring in any hearsay statement
to the extent it supports
or
an attack on the credibility. Yes, sir. Yes, sir.
that I don't disagree with. A hearsay declarant's credibility can always be attacked or supported pursuant to the rules.
Right. So it's our position then that any hearsay statement that supports or attack on the credibility of the declarant is admissible. And specifically in our motion, we have several of them and we appended them as exhibits. So I think that they are now admissible by virtue of 806.
I'm still not sure exactly which ones you're talking about, but state.
And Judge, I'm confused because at the base of it, the defense elicited the hearsay. And then he's trying to bring in hearsay to impeach from the hearsay statement that he brought in. I don't understand this, but 806 says that once a hearsay statement comes in, that other evidence can come in, which would have been used had the person testified. So I think we're still bound by the rules of what can
So the
come
question
in.
is whether or not some of the
Just because someone
statements
may be
that were
impeached on
referred
one
to,
statement
that were
doesn't mean
brought
every
in
hearsay
through this
statement they've
witness,
ever
whether that means
said
that they can
comes
bring in
That's
other
different than
stuff
credibility.
to attack the
So,
credibility
To
of
be honest,
Doug
Judge, I'm a little
Benefield.
confused.
I am too. And let me make sure I understand. you had mentioned something, and I didn't want to get into it too much because the witness was here.
Yeah, 806
And
is
I think this
referring
was
to
also
section 806
mentioned-
of the evidence code.
Mr. Taylor, I think this was also mentioned in the defendant's motion in limine, that there were some discussions about certain evidence not being relevant, and you were to just talk about very surface level things. But it seems like we got, instead of a scalpel, sounds like we got a shovel out and we're going to start digging some holes.
Point well taken, Your Honor. Actually, the discussion was limited to the allegations of abuse. That is to say, both Suzanne and I felt, rather than going down the rabbit hole of litigating whether or not the allegations of child abuse against the daughter were true or not, we would not go there.
So the agreement was limited only to allegations of child abuse.
Yes, sir. And truthfully, we never executed an agreement, but that was a professional discussion.
So yeah, the defense is trying to say,
that,
because of some of these statements that the
Suzanne
witness,
will acknowledge.
you know, brought in just now,
We did have
we
that
should be able to bring in
conversation about
all
the
of this
child
stuff
abuse
about
allegations. I
these
do not
allegations of
remember
Doug Benefield being
specifically
abusive. The
excluding
state is saying,
anything
no, no, no,
before the child
no, no,
abuse
no.
allegations. And if there was
Limited,
miscommunication,
very limited.
I apologize, but I had assumed that that would be a part of the let's not go down rabbit holes, because the issues that have just come
And the
up
judge
have already
sounds
been
very
litigated
skeptical
and
of the
have already
defense
been
right
ruled
now.
on by another judge.
His
So-
comment about earlier about,
I was under the
earlier we were
impression we
talking
were not gonna
about,
get into those
using
that
a
have been
scalpel. Now it
settled.
seems like you're trying to use a shovel. In other words, you're trying to
Again, I
shovel
don't
in a
know
bunch of
as a
stuff
part
in
of the
here.
agreement. I can say this. So there's two general ways a hearing like this can go. And I'm talking very, very broad strokes. One is how I thought we had agreed to do this
Huh.
was that pretty much we're going to let stuff in and object as we go. And then I'll decide the relevance or if things are relevant or not relevant. And I understand that that means a lot of things come in that might not normally come in. And those things may be relevant or not relevant. So I'm going to listen and hear a lot more testimony and see a lot more evidence than I might not normally. But it's to allow you guys to just put on your cases. The other way is we take a step back from that and I will grant or overrule objections as we go. I personally think that'll take a lot longer, but it'll also limit how much evidence is put into the record. And we can do it that way too. My rulings so far, I would think both of you would agree, have been very generous towards admissibility. Because that's what I thought we agreed on. So, but if that approach is then going to be, well, Katie bar the doors, here it all comes. And we're going to spend tons of time. We're going to stop here. We're going to get off the bus and we're going to spend a day looking around over here. Then we're going to get back on the bus. We're going to go a little way down. We're going to get off the bus. We're going to look all around here.
So this is one of the
I'm not
differences between a hearing
doing
like
this
this and a trial.
So I can have
Because you
hours
don't
upon
have the
hours
same sort of risk
about
that
somebody
something will
shooting
get
a
in
gun in
front
a
of the trier
house,
of fact and will spoil
punching
the
a
entire
dog,
case. With a jury, they
putting
are
a
not
tracker
trained
on
in
a
the law. They
car,
don't necessarily understand
peering into
aspects
a
of the
window,
law. So it's very easy
punching a
to
hole in
spoil a
drywall,
case by putting something in
and
front of them
alleged domestic
that you
violence
shouldn't
and
be putting
prior
in front of
marriage.
them. With a
I'm not gonna hear
judge, he
hours and
knows how to
hours of
ignore
testimony.
certain
So
things. He knows how to ignore evidence.
need
So
to know.
what he's saying is,
I'll
you
start
can
with
let
the
in a
state,
bunch
start
of
with the
this
defense.
stuff in front of me.
Are we going to do the plan?
And
that
I
we
can just
originally
decide
laid out,
what's
which
relevant,
is,
what's
hey, put
not
your
as
stuff
we're going
in,
through it.
right? And then I'll figure it out as we go. Or am I going to throttle this down and I'm going to start listening to more objections? Not that I haven't been listening, but take more of the approach
Yeah,
of
there's no jury
no,
for
we're not
this.
letting irrelevant stuff in. We're not going to have hearsay. State.
Judge, I would not want to continue with everything that we're doing now. I don't necessarily think that we need to completely curtail it, But I do think that some of it needs to be throttled down. If there's an objection, I think that you should rule on it appropriately.
All right, so that's a mix. All right.
So I take that to be the former position, which I agree with. I am quite comfortable, there's no jury here. I am quite comfortable with the court parsing the evidence when the time comes for the court to rule and author an appropriate order. And that was why I said I'll address it later. I wanted to make my point and move on. And I'm satisfied if we continue to go with that way. I
All
think
right.
it's going to be consistent with time savings and efficiency.
But it hasn't so far because we're spending a lot of time having this discussion now.
Yes.
So it hasn't been the time savings that I had planned. So I guess my question is, I don't know what statements you want to get in. I don't know what evidence that you want to get in that you're arguing comes in under 806, which, if I'm understanding your arguments, I don't think I read as expansively as you do. I think a hearsay declarant's credibility can be attacked or supported, if attacked, as if the hearsay declarant had testified, but that's still within the bounds of the Florida Evidence Code. I don't think it kicks open the door for every hearsay statement that has ever been made. But the second DCA will tell me if I'm right or wrong. So let's call the witness back and
Okay.
we'll see if we're on the same page and we can go from there.
I believe we were at the end of defense cross, or I was at the end of my redirect.
So
when
this
you
whole
can-
discussion
I don't
was
know-
about
I don't
There
know
was-
if we need the witness.
how much
back.
they're going to let
I
in
will
during
say
this
this,
hearing.
Agreed.
There was recross. The question was.
And it sounds like
how
they
did
kind
you
of
hear
landed
about
somewhere in the
Sully?
middle.
And did you hear about it from Mr. Benefield or Miss Benefield? The answer was, I heard from them both.
So it
Now-
was on defense cross.
I'll just say, I don't know where this is going. I don't know how much you plan to get into defense. I've read, this is not the entire pile of what you sent me, but
Yeah.
this plus everything else you sent, I've read it. I understand,
Defense
well,
filed
the
a
portions of the
hefty
depositions. I didn't
motion
get
to
entire
dismiss this case.
depositions. I've read it. I mean, I understand that what he said about that, the incident with the dog. I understand what she's saying about the dog. I just don't know how far we're going to go down that hole.
I hear you, Judge. We're finished with Mr. Benefield.
Okay. I don't want to curtail you. If you have any questions, I want you to ask your questions.
I understand. I appreciate it. We're on the same page.
All right. All right. So Mr. Benefield is done.
Yes.
Okay.
And he can be released.
That's my next question. After each witness, I will ask, can the witness be released from their subpoena? So, state.
Yes.
Yes, sir.
All right. So we're going to call the next witness, and can you let Mr. Benefield know that he is released from his subpoena? And who's your next witness?
I'm sorry.
Your next witness. ma'am.
Oh, Stephanie Murphy.
Okay. So to answer some questions here, Chelsea Merritt says, if defense wins this hearing, does the case go away? Yes. Yes, it does. Megan Hunter RRT, what I'm asking is in the description, which is why I'm asking specifically if this was the same husband that fired a gun in the ceiling in front of her and his kid when he got pissed off. That's the allegation from the defense. We heard about that a little bit earlier. So yes, same case. Don't know if that actually happened, but that is definitely an allegation by the defense. Reindeer, how come they don't want this to come in? There's, these allegations about abuse. The state is going to want to keep that out as much as possible because it is obviously highly prejudicial for them. But, we just heard this lengthy hearing, well, not lengthy, but this exchange between the parties, the attorneys on either side. Oh, I think this might be the divorce attorney. This might be Doug's divorce attorney.
My notes.
And this is a hearing basically on dismissal. So the defense filed a motion to dismiss the case
Hello, ma'am.
on
My
account
name's
of
Ed White. I'm
her
the presiding
immunity,
officer.
stand your ground law.
As the deputy said, if you get about 12 to 15 inches from that microphone, It adjusts up, down, left, and right to wherever you need it comfortable. And if you just speak in a loud, clear voice, it should pick up everything.
Thank you.
Thank you.
Adam Parks asking if I'll do an
Morning.
update on
Morning.
Magnus Carlsen to Hans
Please
Niemann
state your
case. I
name.
might. I
Stephanie
heard there were
Murphy.
some developments there.
And what do you do for a living?
I'm an attorney.
What type of law do you practice?
I practice family law.
Yeah.
And do you work for someone or are you self-employed?
I'm self-employed. I have a firm in Sarasota.
How long have you had that firm?
I've had the firm for approximately 15 and a half years.
And were you hired at some point by Doug Benefield?
Yes.
Do you recall when you were hired by him?
I first met with Doug Benefield on March 13th, 2018. He retained me on a partial retainer the following day on the 14th of March.
And what was the purpose of him hiring you on that day?
On that day, I was retained for a limited purpose of communicating with Miss Benefield with regard to the upcoming birth of their child.
Okay, so the defendant was pregnant at the time.
Correct.
And do you recall when her due date was?
I believe the original due date was April 8th of 2018.
Okay. And you said your initial responsibility was to communicate with her.
Yes,
So did you attempt to communicate with her?
I did. I sent her a letter via email on March 15th, 2018 at approximately 9:59 in the morning.
And without getting into all the specifics in the letter, basically what was the gist of it?
The general gist of the letter was that with knowledge of the upcoming birth of their child, Doug wanted to express his interest and desire to be part of the birth process, to be present if possible, but also wanted to communicate that if Miss Benefield felt uncomfortable about that, he wanted to respect her space.
Your Honor, for the record, object to hearsay and relevance.
Yeah. Is this being offered for the truth?
No, it's just basically being offered to show that this is how the communication started and that the letter was sent to Miss Benefield.
Okay. Did you want to respond to that? I'll just say, I was not taking this as for the actual truth of this. If it's intended to be for the truth of these matters, then that's a different issue.
No.
Well, I think it's obviously intended to quote unquote educate Ron.
So they're getting to the definition of hearsay. Was that statement about him saying that he wanted to be at the birth of their baby, but otherwise he would give her space?
Yes, sir.
Was that offered here? Was that intended
Wait a
to
Did you ever?
for the truth of the matter asserted?
Let me back up.
Or
I
was
don't
there
know
another
if you
reason
said this,
why they were
but
introducing
what
the statement?
form did you send her this communication?
It was a letter that was saved as a PDF that was emailed.
Okay. Did you ever receive a response from her?
She never responded to me directly, no.
To your knowledge, did she ever respond to Doug?
No, not at that time.
At some time shortly after that, so the baby was born in, or when was the baby born?
Well, baby was actually born quite early. The next day after receiving my letter, she checked herself into Tampa General Hospital and then started a induction of labor process. And so the baby ended up being born about 3 weeks early, I think March 19th of 2018. I may be off a day or two.
So middle of March. Baby was
Correct.
born. To your knowledge, was Doug there?
No, he was not there. He had no idea baby was born.
Did the defendant file for an injunction shortly after?
Yes.
And what date was that?
My memory is that it may have been, excuse me, May 1st of 2018. It could have been in April. There was a bit of a lag between when she filed it and when we had knowledge of it because the injunction was actually denied, but a hearing was scheduled. So Mr. Benefield was not served.
Okay, so just to be clear, you said the injunction was denied. Are you saying the temporary was denied?
Correct.
Okay, so an injunction was filed, a temporary was denied, but it was set for a hearing? Is that what you
Yes,
said?
that is correct.
All right. Do you recall when the first hearing was set approximately?
It was shortly after we found out about the injunction. So I think we found out, meaning I found out on May 6th of 2018 that the injunction had been filed, which is how we knew that the baby had been born and what the baby's name was. And then the hearing was originally set for shortly after that. I think just a couple of days.
Okay.
Ended up getting continued anyway at Ms. Benefield's request.
Okay. So it was set pretty close in time, but it ended up getting continued.
Correct.
Before the hearing was actually held, did you end up filing something on Doug's behalf?
Yes, quite a few things.
And generally, what did you file?
Generally, it was a petition for a parenting plan unconnected with divorce and a motion for psychological evaluation. Those were the initial pleadings that we filed.
Okay. Ultimately, were these issues all to be addressed at the same hearing?
Ultimately, yes.
Okay.
Well, let me clarify. No, because then when the hearing ultimately took place, it wasn't the original petition for parenting plan unconnected with divorce. It was actually an emergency motion for temporary time sharing and parental responsibility. But both cases traveled together, and so pleadings or motions in both cases were heard at the same time.
Okay. So while the motions themselves may have changed, the two case numbers were heard at the same time.
Correct.
So at the time, Doug had an emergency motion for time sharing?
Yes.
And what, just briefly, what is that?
When there's a child, there's no such thing in Florida as custody anymore. Parents have time sharing with children. Ms. Benefield was withholding time sharing of their daughter from Doug. And so the appropriate way to seek time sharing was through the court versus taking matters into your own hands.
Okay.
He was also seeking parental responsibility, which is the decision making.
Okay. And when was that hearing held?
It was held on 2 different days. It was July 30th and September 17th of 2018.
So you did have part of the hearing on July 30th, 2018,
Yes,
and did not finish, I'm assuming?
we did not finish.
What judge was it?
It was Chief Judge Diana Moreland.
And before that first hearing, was there a motion to recuse the judge?
It was a motion to disqualify Judge Moreland.
And was it granted?
No, they appealed that decision and filed a motion to stay pending appeal. That was also denied.
Okay. So the hearing continued.
Correct.
Then it continued again for the rest of the hearing in September.
Yes.
Okay. So I don't want to get into the specific facts of the allegations in the injunction, but if you could just tell us generally what were the topics, the injunction.
It was a wide range of topics. The most alarming was she had allegations that she was poisoned by heavy metals and that the baby had also been poisoned in utero. She alleged violence of a dog.
Oh, I'm sorry. I thought we were going to talk more about the poisoning. So
Okay.
Violence with a dog.
Correct.
Poisoning.
Right. Threats, and that he had discharged a gun in the home.
Okay. After this hearing, did Judge Moreland make a ruling?
She made a ruling at the conclusion of the second day in September. Yes.
And what was that ruling?
Her ruling was,
I'm going to sustain as to her ruling on these issues. I mean, I'll hear,
And
go ahead.
I'm sorry.
Put whatever you want on the
That-
record.
This we may need to have argument about, Judge. It is my
Kurt, thanks so
argument,
much
the
for the
state's
super
argument
chat.
that
And thank you for the kind words.
the content and the manner in which I have the order recorded, the judge made this ruling, set the stage for the defendant's behavior later on down the road. Because she knew that this judge felt the way she did, and she had a hearing in front of this judge 3 days after she murdered the defendant. So I think it's effect on the listener, and I have some case law we can argue if you'd like, but this manner in which this order was given is highly relevant to the defendant's
State of
the
mind.
effect on her.
Yeah.
All right. So you're not introducing Judge Moreland's ultimate order to influence one way or the other to prove that it was correct.
Correct,
It's the effect on the defendant.
correct.
All right.
Whether it be right or wrong, the ruling, I'm introducing it for the effect on the defendant.
Yes, sir.
I don't have a problem with that. The problem that I have, which I think the court is well aware of, is the characterization of the presentation.
Right, absolutely. If it was for the purpose of, hey, judge, this other judge ruled this way, therefore, that's what we want.
Correct.
But if it's to show the effect, and yes, that one of the cases you had submitted illustrated that very point. So I get that. All right.
I want to make sure we're talking about the same thing. I don't have a problem with the state's theory that this decision prompted the subsequent action. What I strenuously object to is the statement by Judge Moreland, the characterization of the quality of the hearing. That I think should not be stated in this proceeding. I think it's irrelevant. The decision itself, I don't have a problem with. I can tell the court, well, let me just leave it right there right now.
All right. I don't know what the statement is. I'm going to have to hear it eventually, and then I just won't consider it, but it was,
Approach the bench.
yes.
Oh. So now this is a truth. I mean, we don't even have a jury to be worried about overhearing this. Whoops. Okay, let me answer some questions here while we are waiting here. So Chrissy Lyons says, for a case like this, how long would her team work on prepping her for questioning and cross-examination? It really depends on how long they anticipate her testifying, how much information, and like how much information they would be going through. I would anticipate for a criminal defense case like this, for a murder case, I think, I don't know. I wouldn't be surprised if she came in a couple days in a row to their offices to just spend that time prepping with them. Genergy, was Doug a wealthy man? It sounds like he was. At the very least, he was very secure in his finances. He had served in the military, I think in the Navy. He was a Navy veteran, I think they said. And oh gosh, hang on one second. One second. So, and I think that he was financing her projects here. So it sounds like he probably was. Igloo Pop, so there's no jury for this. No. Genergy. So could there possibly be no trial whatsoever? Yes. Yes, that is definitely a possibility here, because if the defense wins this hearing, the case is dismissed. If the prosecution wins this hearing, it could be that that the defense decides to negotiate something with the state for her charges, because they might say, this is just, if we can't win it here, we're not going to be winning it at trial in front of a jury. I don't know. There's other evidence that is going to be addressed here, talking about the
Let's
manner
do
in which
this.
he died.
We got some new
He was shot in the
headphones,
back as
and
opposed to the
as
front.
you, as it
Suggests
invariably
not
happens
self-defense.
when you introduce new hardware into a system, we've got to get it fixed. So why don't we do this? It's kind of a good time for a mid-morning break. So why don't we take about 10-minute break? It's 10 after. We'll see everybody back at
Oh, good.
10:20.
We'll get caught up.
Get this issue solved. Ms. Murphy,
Yes.
the rule of sequestration has been invoked. We're going to take a 10-minute break, so you will be, I'm sure, milling about the hallway. I know you're familiar with the rule of sequestration and what that means regarding your testimony and who you can
Yes.
talk to. Please make sure you follow that closely. We'll see
Absolutely.
you back in about 10 minutes.
Thanks so much.
So, okay. So yeah, we're going to be taking a 10-minute break, which means we're going to be basically caught up here. Let's see if we can take this to live. Yeah. Okay. So yeah, we are caught up. So yeah, there could be no trial whatsoever. There is other evidence that we are going to be getting into. The forensics on, he was shot 4 times in the back. There's no evidence that he had a gun. This is from what I've been reading in the brief research that I did before this hearing. There's also, so shot 4 times in the back. The forensics suggests that he was not in a defensive stance. So, the idea that she was in reasonable fear of her life, they've introduced so far, there is an allegation, a suggestion that he was, well-versed in martial arts. He always had a firearm on him. He, it would always be loaded, these kinds of things. He was in great shape at the time that he died. There also, I would imagine that we're going to be getting into like height and weight differential between the two, because although they said that he was 5'9", 5'10", which is, I think that is technically above average in the United States, but not by much. So he's not exactly like a big, tall guy, but she also was a ballerina. So she might be tiny, even in comparison to an average sized man in the United States. So, yes, there's quite a bit here. And if the defense loses this, that might be a calculation that, and by the way, the motion that they filed for this was apparently like huge, like a very, very long, I mean, the judge referenced it, right? He showed that like stack of papers. He's like, this isn't even everything that you guys filed. And I read all of it, but there's a lot here. So it could be that the defense is throwing everything they've got at this because they might be thinking this is our best shot. And if it actually goes to trial, we don't have much of a shot. So we'll see. Christian Williams, they haven't even done jury selection right yet. So we are well before trial at this point. I would anticipate trial is probably not going to be 4 months before this. But this is basically, like I said, this is a hearing essentially on a motion to dismiss the case, because the defense is alleging that there is this immunity that she has because she was standing her ground. She had a reasonable fear of her life. And that he was threatening her life, and that the fear was reasonable, and that she used reasonable force. If he didn't have a weapon on him, I'm out of sync. I know there's something up with my internet, I suppose, but it'll eventually come back. I'm sorry, guys. This is in Florida. And Marverin, how free is she to testify with a client that has passed away? That's a good question, because this is an attorney, and you have a client confidentiality that attorneys have, and that goes beyond the grave. They take that with them. So she's able to testify to some things, just not the confidential conversations that she and he had having to do with her representation with him. But she can testify to things that she said, things that were knowledgeable to other people. Like, so for example, like talking about the letter that she sent to Ashley, and the conversations around that. She was able to testify to that, but talking about like, well, did you go into, this conversation that you had with him or that conversation that you had with him about various pieces of evidence, there's going to be limitations on what she can talk about, but we have not yet hit that line at this point so far. Bronwyn W. Question: what do they mean by truth of the matter asserted? How does that change the witness's testimony? So what they are getting at is the definition of hearsay. So hearsay, is a way to exclude statements from coming into trial. And the definition of hearsay is it's an out-of-court statement that is offered at trial, offered to prove the truth of the matter asserted. So the definition of hearsay, it's not just any out-of-court statement. You can have out-of-court statements that are allowable in court. It can either be one of the many exceptions to hearsay, for example, a business record. You can allow in financial records for stuff because, so long as you meet certain criteria for business records, then so there's that, but there's also just the definition of hearsay. So the crux of it is, why are you offering this out of court statement? Are you offering it to prove that he in fact wanted to see the baby at the birth of the baby? Or are you offering it to talk about the reason why he hired her, or the beginnings of her involvement in the relationship between Doug and Ashley?
All right, we are back on the record, and go ahead and approach attorneys.
Okay.
So yes, ma'am, anytime the attorneys approach, put those headphones on. We'll turn them on, that way you can hear.
Thank you.
And so they're going to have a quick sidebar
And
now
the
that
first
they're
thing I'm
back
gonna
in.
do is confirm you can hear me. Just give me a thumbs up.
Interesting. Okay. And so this question here from Genergy: what is an injunction? An injunction is it's basically where the court tells someone that they have to do something or they're not allowed to do something. So you can have a positive injunction or a negative injunction. Here, what they are talking about is this injunction to essentially keep Doug out of the baby's life. It sounds like that's what was filed here in this case. So when they're referring to an injunction, it sounds like the defendant here, Ashley Benefield, she filed an injunction against Doug, basically alleging all of these things against him, saying he had been poisoning her with heavy metals and poisoning the baby with heavy metals during the pregnancy, and that he discharged a gun in the home and he punched a dog and all of this kind of stuff. All of these crazy allegations, which might be true, might not be true, regardless of whether or not they're true, they're kind of crazy. But so she filed this injunction basically saying, hey, I need full custody of the child. He needs to be kept away from our child because, he's a danger to her, her life. I think it's a daughter. I think it's a baby girl. And so we were getting to, at the very end of the testimony that we've heard so far, was the attorney was going to talk about the family court judge made a determination on these injunctions. And if you've researched the case, that the judge
Can you bring
found
Ms. Murphy,
not a
Attorney Murphy, back in?
scintilla
Thank
of
you.
truth to those allegations, not a chinchilla. So that's really what the prosecution wants to get in one way or another. But it makes sense that what they're saying is this is to show her state of mind going into this, to say, look, she's trying to, keep her baby away from Doug. And she, she, if you're from the state's perspective, they're like, she went cuckoo for Cocoa Puffs at the time that she got pregnant. She went off the rails completely,
welcome
started
back,
making all
ma'am.
these allegations.
Do you
Now
need to try
she's
and
being
discuss
told
the
she
case
has to
with
share
you or
custody with
anything about
him,
your testimony?
No.
and she's gone crazy, right? That's what
So
they want to get
We
at.
were talking about the end of the hearing on September 17th, 2020, where Judge Moreland made a oral order.
Correct. She made an oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes,
She was in court then.
yes.
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
Okay. What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency time sharing hearing.
And you said these are your initials. So
Correct.
when you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
State would enter in evidence State's Exhibit 1.
Same objections?
Yes, sir.
Yes, sir. Overruled for the same reasons. I'm not accepting it for the truth, just the effect on the listener.
Okay. And then the state will publish it's about 10 minutes long.
I think Mr. Sessions start with that one thing, even though I find it very reticent to ever say, well, someone else investigated this, so there's no problem. But I do appreciate the fact that Mr. Sessions argues that people investigated and found that his client wasn't the perpetrator of any domestic violence, et cetera. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this particular case. He had absolutely no concern of self-harm, domestic violence, or any other type of spurious activity on the behalf of Mr. Benefield. Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything
Scintilla.
that was testified to, at least in this hearing of Ms. Benefield. Court finds that it starts from basically the absurd of the conversations of what she would have had with a child, searching the room, finding a shadow box, being so upset, but also at the same time the testimony where she said, well, they were absolutely liked me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, and then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms. Benefield has ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's
Pretty
testimony
strong
was
conclusion. I'm not going to lie.
suspect. I don't think that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative, and that his information concerning the answered questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. And most important to this court was the explanation of the misinterpretation or the use of an improper range, which I think even a cross-examination, there was a misunderstanding that there is a range of these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the respondent goes up there. They're at the respondent's home. Petitioner is up there. He's had back surgery. She moves back into the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments, but there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. That on 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal, and that from that point they begin to pursue having a child. The court will find there is one incident of alleged domestic violence. And I got to tell you, it is de minimis, even though it's huge whenever how it was executed, the shot into the ceiling. Court is going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds that Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Miss Benefield continued to pursue a relationship and to have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week, he shot a bullet in the ceiling. That's absolutely not what happens. Instead, she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy marriage, that we're going down, we're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. That she finally they finally find out that in July of 2017, they have conceived a child, and that, or they think that that's the date they've conceded in retroactive review, which tells this court that during that period,
Marvin, it sounds like it was before their marriage and before the American National Ballet endeavor.
Relationship. The court does not find credible any type of animal cruelty in this particular case, nor does the court find that the other incidences alleged of punching the wall were ever directed completely at her, nor were they meant for intimidation. Court's also going to find that 3/2017, they do find about the pregnancy. It's confirmed. And at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Mrs. Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Miss Benefield being in the home, not making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors.
She never went to a doctor.
Indicating in the least that she has any type of poisoning that is appearing in her system, that she has been the victim of domestic violence, and or that this child, Eva, has been the victim of domestic violence.
That's true, because they have Eva, his daughter from his first wife, was also living with them.
Even in Florida, we have Irma come through, I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman is going to harm her when she's up there. Court will, one of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield, I guess, trying to curry some kind of upper hand in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child, that he has now not had any contact with. Court's going to find there's been no violation of any injunction. The court did look at and has listened to the testimonies that were provided concerning the injunction that was entered. Quite frankly, it sounds like the court was, when you listen to the transcript, was actually telling both of them they needed to stay away from each other, and that certainly there was no violation of it whenever there was the oral pronouncement, only to be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token, she's participating in articles concerning the alleged poison, etc. As far as the last comment on the poisoning, there is not one piece of evidence, like I said, that has been established that even if she was being poisoned, that there has been a suggestion of a nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that because it happened, it had to be him, especially when I have, in all senses, not a credible witness is the only person that's asking me to speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident. And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
So
After the judge's ruling
interesting.
on the injunction, which would be the defendant's motion, did she make a ruling on your motions?
Yes,
And that was time sharing with the child?
it was time sharing and parental responsibility.
Okay. And what was the order, or what did the judge say Doug could do?
There was a temporary time sharing schedule that was increasing in frequency and amount. So it started with the first day that he was going to be able to meet his daughter, just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing. Then there was another jump. And so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits, maybe holiday related, but then the other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Moreland ordered that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions. But the court specifically ordered that Doug Benefield would have ultimate decision-making authority regarding health-related or medical issues. And the order made very clear findings about her extreme concern with regard to Ms. Benefield's medical decisions up to that point.
That's
Which is
kind
why
of a
she
big
ordered
deal.
ultimate decision-making authority.
And
Because
the concern was for the medical decisions.
in
for
family
the
law,
child.
Correct.
the likelihood of that ending up in favor
So
of the
why is
husband
there an
is
escalating frequency
not-
of visitation with the child?
not very often.
Well, Doug had never even been allowed to meet his daughter. So she was, I believe, 6 months old by the time he met her. And so it's just appropriate that you don't just dump a baby with, who was that at that point, a stranger.
Okay.
So it was just to grow in a reunification or a unification, I guess. There's nothing to reunify.
To get the child used to who she was going to.
Exactly.
Okay. So the first time sharing where there was an exchange of, and the daughter's name?
Her name is Emerson Grace Caney.
Okay. And can you spell the last name?
I believe it's Caney. I have to double check my file to be completely certain.
And where were these exchanges of custody to take place?
Well, according to the court order, they were to take place at Manatee County Sheriff's Office, and that's where the first exchange took place.
Were you present at the
Yes,
first exchange?
I was.
And did you arrive with Doug or were you separate?
We arrived separately. By the time I arrived, he was already there. We were both there earlier than the scheduled exchange time.
Galaxy, she's sponsored by Coach.
And was this the first time Doug was meeting his child?
Yes.
What happened during this exchange? Did the defendant ultimately show up with the child?
Yes, she did.
And just explain how that meeting went.
Okay. I had been sitting with Mr. Benefield in his truck, and when he saw Miss Benefield enter the parking lot, he moved the truck closer to the entrance to the building, and she was out in front of the building with the child. Doug and I then approached Miss Benefield, and I hung back a bit, and Miss Benefield saw me, looked at me, and then immediately said, "Are you dating her?" She was very indignant, very upset, and then I responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Miss Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench, especially when she transferred the baby over to his arms. They kept talking for 5 or 10 minutes or so, and I kept waiting also there. Then Mr. Benefield turned to me and said, "Okay, we're going to go. Ashley's going to come." And so I pulled Doug aside. We had a communication about it. I warned him that it was not a good idea, given all the allegations that she had raised up to that point. And he said that he was aware of the concerns. He agreed with me, but he wanted Emerson to be comfortable, and he thought having Ashley there, as she was insisting, would help Emerson be a little bit more comfortable. So then I watched them Ms. Benefield strap Emerson into the car seat in the back of Doug's truck. She got in the back seat and they left. I, of course, just left in my own vehicle.
And approximately when was this?
This was September 21st.
September 21st of
Of 2018,
2018.
just a handful of days after the hearing.
So from this point on, at least from your perspective as the family lawyer, was there sort of a peace between the two?
Well, there was. In fact, they had an agreement that we memorialized into a joint stipulation to expand the time sharing that Judge Moreland had ordered. So within a handful of days after seeing his daughter for the first time, Ashley and Doug had a written agreement signed by both attorneys and submitted to the court that said you get to see the child even more, exchanging the child anywhere they agreed. If there was no agreement, the exchange default would be at the Manatee County Sheriff's Office, but more frequently, not supervised by her. And that then was the norm for quite a while.
And how long did that last approximately?
About 11 months, I would say, from September of 2018 until August of 2019, they were together all the time. Doug's time sharing was always with Ashley present, so they were certainly behaving as a family. They were quite active on the social scene.
I was going to say, did you ever see them?
I did. They were in magazines. I think they were even in SRQ magazine at some kind of ballet gala event together.
So at some point, this piece did not last.
Yes, it did not last.
About when did things start to go downhill?
Unbeknownst to Doug, they were about to go downhill in August of 2019. He was scheduled to move in with Miss Benefield and her mother. So he'd kept an apartment or a little condo here in the Sarasota area, but his lease was running out. So they had agreed that he was going to move into their home.
Whoa.
They moved all of his things inside to their home, emptied the storage unit of his contents into Miss Benefield's home. And the day he was scheduled to move in, as he always said, she ghosted me. She didn't answer the phone. And so I think it was August 16th of 2019 was the day that he was supposed to move in, and then suddenly everything changed.
Okay. So
Just for the record, you want to continue an objection to hearsay and relevancy.
Yeah, we're getting pretty in-depth with this whole situation.
okay, and I can move along.
Okay.
So at some point, did Ashley start filing complaints
Yes,
against Doug?
yes, she started again, yes.
And how many complaints were there, if you recall?
I would say a half dozen. They started, I think, in December of that year. And then they just kept on going for another 4 or 5 months. Oh, and there were complaints about the child.
Okay.
They were
So
not about her.
not about her complaints of abuse of the child.
Correct.
Okay. And at some point, did Ashley file for another injunction?
Yes.
And were you involved in that process?
Yes.
Who, I'm sorry, as a part of that investigation concerning those complaints and that request for an injunction, was a psychological evaluation ordered?
It was not ordered by the family court, but there was a psychological evaluation that was put into place through CPS. And I believe it was Detective Moreland.
Child Protective Services,
Okay.
for those that don't
So
know,
at some
CPS.
point, a psychological evaluation of both Doug and Ashley was ordered.
Yes.
And to your knowledge, Doug participated in that.
Oh, yes.
Who was that doctor?
Dr. Brad Broder.
At some point around this time, did Doug file for divorce?
He did. In November of 2019, we filed a motion for leave to amend and then a amended petition for dissolution of marriage.
Was that your case number? Did it run along with her injunction case number as we talked about before?
Yes, they were companion cases.
Companion cases?
Yes.
Okay, thank you. When was it set for a hearing?
Again, it was a hearing that was set and then moved a couple times. So I think it was originally set for hearing in May of 2020, moved to August, and then moved to September of 2020.
And do you recall the date in September?
It was scheduled for September 30th,
Okay.
2020.
Were you ordered to mediation first?
Yes. At Ms. Benefield's request, she filed a motion for mediation. The court entered an order of referral to mediation.
Okay. And during the mediation, were you present at the mediation?
Yes, we were all present via Zoom, but not in person because it's during COVID.
Okay. But the defendant was there
Oh.
via Zoom
Yes,
and Doug was there via Zoom
yes,
and the mediator.
yes. As well as Ms. Benefield's attorney was also present.
And who was that?
Faith Brown, at the time, she had been let go from her prior attorney.
Okay. So what did Ashley say at the mediation about their relationship?
Both of them said,
It's sustained.
What did Ashley say? It's the
Hold on,
defendant.
This is during a mediation? Is there some exception? Mediations are generally private and confidential.
I can move on. I thought it was a hearsay. You're saying something else.
No, I'm assuming, you tell me what your objection is.
Objection, it's.
Okay.
Yeah, I mean, I don't, unless you have some case law that there's an exception to the general, I'm going to say secrecy, but the privilege, the mediation privilege.
Communications,
I'm not
settling
aware of any
communications,
case law, but you
mediation
may have some that there's
communications
an
are
exception
generally
in a
considered
criminal
confidential.
prosecution.
I do not, Judge. I'll
Okay.
move on.
All right.
So that was a correct,
At some point after the
Determination.
mediation, did Ashley agree to drop the injunction?
oh, she'd agreed to drop the injunction before the mediation, but it wasn't just that she was going to drop it. It was a quid pro quo situation.
And what was the quid pro quo?
That he dismissed his divorce case and again, another emergency motion for time sharing for the parenting plan, and the joint motion to release the psychological evaluations conducted by Dr. Brad Broder.
Okay. And in fact, were those things all dismissed except for the psychological evaluation release?
They were not.
Okay. The hearing that was set for 9:30, what was to happen at that hearing?
There had been a lot of discussion leading up to that, and the plan was that the September 30th hearing would not be held on the injunction because the agreement was that once the psychological evaluations were provided, then the injunction would be dismissed and the family law case would be dismissed.
Okay.
So the 30th hearing was supposed to be the joint motion for release of psychological evaluations.
Okay. And what day was Doug murdered?
So that he was murdered on Sunday, September 27th, 2020.
3 days before this hearing was scheduled.
3 days after the mediation, 3 days before the court date.
And who was the judge scheduled to be at this hearing on the 30th?
Chief Judge Diana Moreland,
So the same judge that had heard the rest.
same judge.
In all of the times that you dealt with Doug, did he ever have what I would term like an overly angry demeanor towards Ashley in your presence?
No,
Okay.
which was kind of a source of conflict with Doug and I, actually. He was very passive, very accepting, and always looking for excuses or reasons, not angry. Just surprising. He was also very suspicious of her, but never angry.
Okay. And did he always blame her for everything, or?
No, not at all. I think he often blamed Dr. Hildegard Staninger, who was related to the Charleston labs, who obtained, involved with the poisoning allegations and the lab results. But no, not always Ashley. He was always trying to look for, some explanation as to her conduct.
Thank you. I have no other questions.
Thank you.
All right, Cross.
All right, cross-examination now by the defense.
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
You practice family law,
I do.
and you've been doing it, I think you told us, approximately 15 and a half years you've had your own firm?
I've been practicing family law for approximately 21 years, but I've had my own firm for about 15 and a half years.
Okay. And in the course of
That's a long
your
time.
practice, have you had the opportunity to represent both petitioners and respondents in domestic violence injunction actions?
I have.
And have you represented them, Ms. Murphy, strictly in family court, or have you also continued in representation in those cases where the disputes end up in criminal court as well?
Only in family court. I do not practice criminal law.
Okay, so on those occasions, you were referred out.
Yes.
All right. It's the nature, is it not, in family court matters that the litigation is often, shall I say, spirited?
It can certainly be the case.
Okay, it's not unusual.
It's not unusual.
Would it be fair to say that the litigation can sometimes, depending upon the parties, be quite aggressive?
Never to this level in all of my 21 years, but it can be aggressive.
All right,
This was extreme.
and it can also be determined, can it not?
I'm afraid I don't understand that question.
Litigation, in general, in family court matters.
Determined meaning,
Determined meaning neither side lets up. You have two people who fundamentally develop a real dislike for one another, and they just pour their heart and souls into the litigation.
yes, unfortunately, that happens.
Yeah. You know, they shoot more family lawyers than they do criminal.
I've heard
lawyers.
that. I think there's more violence on the family law floor than on the criminal floor.
Yes,
Um,
this is
the
what I've heard from
litigation can
actual
often
family
be
law
petty
attorneys.
as well, can it not?
Sometimes.
Yeah, where you get two parties that are arguing over a pet turtle, for example.
Right. I mean, this was the opposite of petty, but
Yes.
yes, it certainly can be.
All right, and you are, of course, like all of us, an advocate.
Yes,
And in this case, you were an advocate for Doug Benefield,
yes,
and he paid you, did he not, to be his advocate?
he did.
During the hearing that we heard, the ruling for which I think it's a safe bet that the petitioner did not prevail. But would you agree with me that Judge Moreland did recognize that your client, Mr. Benefield, had fired a gun in the home when Miss Benefield was present?
Yes, she said that in her
Yeah.
ruling.
And she also recognized that he had apparently punched holes in the drywall.
She did say that.
And in fairness, I believe Miss Murphy, she dismissed the firing the gun in the ceiling of the kitchen as too remote in time.
I believe that's what she said, yes.
And as to the punching of holes in the wall, I think she said it was not directed at Miss Benefield, but just out of frustration.
I don't remember that she said that. She certainly could have.
Okay. Having just recently heard it. So in cases of domestic violence injunctions, would you say what percentage of your clients are females and males that seek domestic violence injunction protections?
Well, I can't tell you if it would be my clients. I think in the cases in which I'm involved, the majority is the female client is seeking an injunction against the male.
Yeah.
That's not necessarily indicative that the female is always a victim of domestic violence, because men can also be victims of domestic violence.
Yes. Now, through your 21 years worth of experience in family court, I'm sure you've come to learn that there are some stereotypical factors that seem to be rather common with a lot of abusers. Would you agree?
I do not necessarily agree with that, no. There are different types of abusers.
All right. Would you say that it's reasonably common in those instances where you've represented females seeking domestic violence injunctions against males, that the males are often controlling?
That is sometimes the prevailing foundation for why the domestic violence occurs, but not always.
Is that a yes?
No, it's a no, not really.
It's a no, not really, as opposed to sometimes?
Sometimes.
Okay. I'll take sometimes.
Okay.
All right. Have you had experience in those instances where you've represented females seeking protection from domestic violence, that the males are sometimes jealous and very possessive?
Judge, I'm going to object to this line of questioning as irrelevant.
I think it may be. I don't know. The witness can certainly say yes or no, or agree or disagree.
That is one of the most rare reasons for the domestic violence in the cases that I've had in which I've represented the women. So jealousy is usually not a factor or a major factor.
So you've seen it.
I've seen it, yes, but not often.
That was my question. Have you experienced in representing some of these females seeking protection for domestic violence against males, that they have employed a strategy, which obviously has not been successful, of appeasement over the course of time, and finally it builds to a sufficient crescendo that they end up as a client of yours?
I have seen that.
Okay. And by appeasement, we mean, do we not getting along, going along for fear that the reprisal will be greater?
Yes, that is true for both the female victim, if you want to use that word, as well as the male victim.
Mm-hmm. When you bring a petition for protection against domestic violence in the family court, are you foreclosed from returning and seeking a second petition?
Do you mean if a petition is denied, can you then file a different petition on the same allegations?
Not on the same allegations.
Okay, then, no, you're not foreclosed. You can file as many domestic violence injunctions as you like,
Correct.
no, regardless of how many times they've been denied.
Correct. So in other words, you've had a domestic violence petition denied, and then 2 months later, additional acts occur. You are entitled to go back to family court and file another domestic violence petition.
Of course.
So what he's getting at is,
And in fact, have you done that on behalf of clients in the past?
I just want to clarify, I don't file petitions for injunction. So a party would file that on their own, the clerk's office. So my involvement is usually after an injunction has been filed. That is when my involvement begins.
And have you represented people who have gone to court multiple times? Or do you only go one time?
Oh, no, I could go multiple times. I just don't think that I've ever had a situation where I've represented the petitioner who has made multiple injunction petition filings. I represented several respondents who have been themselves then the victim of spurious litigation and abuse of the injunction process by repeatedly filing injunctions.
When Mr. Benefield was living here in Manatee County, he had his own apartment. Is that correct?
He wasn't not living here full time, but yes, he had an apartment at times during this period of time.
You're not aware of any point in time where he resided with Miss Benefield in the home where the shooting took place?
My understanding is that he did not.
so just really quick, what he's getting at here with this is, and we can catch up because there's likely to be another recess at some point. So no worries about being a little bit behind by pausing it. What he's getting at here is that, you know, it is totally possible that a partner who is divorcing or separating or, you know, somehow, you know, they are, you know, not in a good relationship, that you could say that they were being abused, that they have multiple instances of being abused by their partner. They can file an injunction against that other person for each instance. If they had a hearing on an injunction at one point, then, you know, and then the judge denied it, but then the next day, then the person, the other side, they do something else to abuse them, then they could seek another injunction. And what he's getting at is he's kind of laying these breadcrumbs, right? Because I anticipate we're going to see something that we're going to see a lot of injunctions. I mean, that's kind of what she's already talked about, right? She's already testified to that she made all of these claims one after another over 6 months. We might get into more details about this. But that's what he's getting at, is like, it's entirely possible, right, for this to be reasonable on her side, that she felt that she needed to file all of these injunctions.
I don't believe I have anything further. Give me a moment, Your Honor.
All right.
That's all, Your Honor. Thank you.
Thank you. Redirect?
No.
Can this witness be released?
Yes.
Mr. Taylor?
Yes.
No
All right.
redirect.
May be released from your subpoena. Thank you very much. State, you ready for your next witness?
The state would call Amanda Conlon.
Okay. So, okay, some questions here that were in the chat. Dogbert, why is there a reference to standard ground if it was in their home? Wouldn't it be castle doctrine? Depends on the state. Different states call it different things, but basically, it's a self-defense self-defense argument saying that she's saying she was in her own home. He didn't have a right to be there because he wasn't living with her. That's why they keep pressing on. He had another apartment. He wasn't living with her. So this idea that he didn't have a right to be there, she did, and that he was abusing her, and she had a reasonable fear for her life. And Kelly's Corner, I will save this one. And any other questions? I know that there's some folks that are newly joining us, some confusion about, or not confusion, but
As the deputy said,
not much knowledge about what the case is
that
about.
Microphone adjusts up, down, left, right.
We'll
however you
we'll
need it.
recap a little bit.
Speaking a loud, clear voice, we should hear everything. Yes, ma'am.
Good morning.
Morning.
Please state your name and spell your last name for the record.
It's Amanda Conlon, Conlon,
And how are you employed?
Sheriff's Office Crime Scene.
And how long have you been so employed?
16 years.
And can you explain generally your duties as a crime scene technician?
To document the crime scene through photos, video, sketches, collect evidence, process evidence.
And did you obtain any education that helped you with that position?
Yes.
And what was that?
I went to St. Petersburg College for crime scene.
And did you get training once you began working with the sheriff's office?
Yes, we're sent to training all the time.
And that has continued?
Yes.
Thank you. I want to draw your attention to September 27th, 2020. Were you working that evening?
Yes.
And were you asked to respond to a scene at 11331 White Rock Terrace?
Yes.
And is that here in Manatee County?
Yes.
And do you know approximately what time you arrived there?
About 8:28 that evening.
And pardon me, were law enforcement officers on scene prior to your arrival?
Yes.
And without telling me what you said, did you speak to them to kind of find out what was going on?
Yes.
After speaking to them, what, if anything, did you do first?
I went next door to the neighbor to collect a gun.
And are these single family homes?
Yes.
And where was the neighbor's home in comparison to the home at 11331?
Right next door.
And did you in fact go over there?
Yes.
Okay. And did you retrieve a firearm?
I did.
Who did you retrieve it from?
From the homeowner.
Was that a Mr. Saint or Sant?
Yes.
And did a law enforcement officer accompany you to secure the firearm or make it safe?
Yes.
Okay. And who was that?
Ackerman.
And did he in fact secure it?
He did.
Okay. And did you observe it to be loaded?
Yes.
And did you observe what type of what caliber it was or what type of ammunition was contained in the firearm?
It was a .45, and Hornady was the brand of the bullets.
HORNADY?
Yes.
Okay, thank you. Did you at some point enter the home at 11331?
Yes.
And was that as a part of the execution of a search warrant?
Yes.
And what's the first thing you do when you enter a crime scene?
Start taking photographs.
And do you document the entire scene first
Yeah.
with the photographs?
Yes.
And then after you have documented the scene as it lays, what's the next thing that you do?
And then I would place down evidence markers of evidence throughout the house.
And those are the yellow tents that we often see in these photos.
Yes.
And is that the process in which you followed in this case?
Yes.
I'm going to show you what's been pre-marked as states 2 through 19. Will you review these and tell me if you recognize those items?
Okay, so we are going to see some gruesome images, guys, more than likely. So, well, actually, maybe not, because it's not going to be put up for a jury, but the judge
Yes. I
might
recognize
want
them.
these on a screen.
how do
So
you
we
recognize
might
them?
see some gruesome images. So
They're photos that I've taken.
trigger warning.
And with the exception of number 3, I believe that's a floor plan.
Yes.
And as far as 2 and 4 through 19, they appear to accurately depict the scene as you saw it the night you were there, September 27th, 2020.
Yes.
And then as to number 3, does it appear to accurately depict a portion of the home as you recall it from when you were there in September?
Yes.
Your Honor, at this time, the state would ask to enter states 2 through 19.
Got no objection.
Received.
Thank you, Your Honor. So let's first look at states 2, and I'm going to display them digitally before you. And can you tell me what we see here in states 2?
Let me just ask, instead of turning down the lights, Ms. Conlon, are you able to see these sufficiently?
Yes.
Okay.
All right, so we might be seeing some gruesome images.
Go with the lights on for us to see it.
Oh, it is?
Yeah.
Okay, fair enough. Thank you. I didn't
All
want
right.
anybody nodding off.
This is the
Thank you.
murder weapon or the killing
Ms.
weapon,
Conlon, I'm gonna
depending on
give
which language we want to be using. It is kind of surprising that the
And
prosecution is
again,
able to
sir,
say that he was
if you
murdered.
need to reposition anywhere around the
trial, I
courtroom,
anticipate
wherever you need
they
to
won't
go
be able to.
see, please feel free.
Ms. Conlon, what is it that we see here in states 2?
It's a firearm.
And what firearm is that?
I believe it is the 45.
And is that, it's back in your lab as opposed to when you collected it in the home, is that correct?
Correct.
And we see a magazine. It appears to have ammunition in it.
Yes.
And then the firearm, which has been locked back, and a holster, is that correct?
Yes.
And then there's one round laying in this picture. Would that be if it had been in the chamber?
Yes.
Thank you. I'm going to show you states 3. This is the floor plan we talked about a moment ago. It's not the complete home, is that correct?
Correct.
When you entered the home, how did you enter?
I entered through the garage, which would be right in this area.
So that the laundry room has what appears to be 2 doorways. The bottom one would be an exit to the garage?
Yeah.
So when you approached the home, you walked through the garage?
Yes.
And what observations did you make, if anything, of the driveway or the garage as you entered?
There was a U-Haul truck. There was a pod there. There was boxes. You could tell they were moving.
And when you entered the home, did the home appear to be furnished, or did it appear as somebody had already completed much of a move out?
There was still a couch in there. There was still some furniture, but the majority was being boxed up and everything.
And we see 2 bedrooms here. Were there only 2 bedrooms in this home?
No, there's a third one, and it's past the living room and kitchen.
This
So,
would be the top of this picture.
yeah,
correct?
it would be up there,
And how would you categorize that bedroom?
the master bedroom.
And then we have 2 bedrooms here on the left, one being a child's bedroom and then one being Miss Benefield's bedroom. As far as you know, is that accurate?
Correct.
What, did you enter the room called the child's bedroom?
Yes,
And what about it made you believe it was a child's bedroom?
because it had kids' stuff in it, kids' clothing.
Did you find anything of evidentiary value in that child's bedroom?
No.
Did you enter the bedroom that we have on this floor plan marked as Miss Benefield's bedroom?
Yes.
And did you find things of evidentiary value in that bedroom?
Yes.
And did you document that bedroom in the remainder of these states' evidence?
Yes.
Thank you. What I'm going to show you first is states 4. Oh, sorry. Can you describe what we see here in states 4?
I'm in the corner in the back, just taking overalls. There's blood on the floor, and there's a bullet hole right here.
And I think we have a close-up of that bullet hole once you marked it.
Yes.
That hallway there, is that the hallway we saw on the floor plan that adjoined that child's bedroom?
Yes.
Thank you. And what is on the other side of this wall where you said I think you can actually see the bullet hole there. And then there's a socket on the wall. What's on the other side of that wall?
The bathroom.
This is states 5. Is this the same area in the bedroom?
Yes.
And the item or the area there, that's a closet with the bifold doors?
Yes.
Okay, thank you. And when you entered the room, was the mattress up against the wall like that?
Yes.
Had anything been moved or touched to your knowledge prior to you taking the pictures?
No.
Where are you standing in state, this is state 6. Pardon me. Where are you standing when you take this photo?
I'm in the doorway.
Where the one we saw, the bathroom would have been on your right?
Correct.
And we see tent markers here, 1 through 6. Is that correct?
Yes.
Can you tell me what was at tent markers 1 through 4?
1 through 4 are casings.
And did you collect those items?
Yes.
And do you remember the caliber of those casings?
The 45.
And were they also the Hornady?
Yes.
Okay, I think I'm saying it wrong, but.
I might be saying it wrong too.
And then I see here, there's a black tripod thing there in this top picture. What is that?
It's a light.
Okay. And that's something you placed or another crime scene tech placed there?
Yes.
And how about number 5? What is that tent marker number 5, which is near that tripod?
A projectile.
And then number 6, what is number 6 marking?
Blood.
I'm going to show you states number 7. Is this the projectile you said was at state or at number 5?
Yes.
Okay. And did you collect that item?
Yes.
Now states 8, I think you're looking back towards that wall in the hallway. Is that correct?
Yes.
And can you tell me what it is at state 7?
The hole right there.
And I'm just going to zoom in so you can. And there appears to be something below it other than your sticky number 7.
Yes.
And what is that?
It's a ruler.
Is that just for scaling?
Yes.
Thank you. I'm sorry, I got ahead of myself. Did you find any other holes other than state 7? There was a, what did you call it, a bullet hole?
Yes.
Yes. Did you find any other holes that corresponded with state 7?
Yes.
Okay, and so can you tell me about those?
So they would be in the bathroom, in the cabinet. So I marked the one after that 8, and then 9 was the exit hitting the cabinet door, and then 10 is the actual on the other side of that cabinet.
So 8 would have been the back of the cabinet?
Correct.
The
Yes.
opposite side of 7?
Yes.
And then it traveled through the cabinet door, which you did as 9 and 10?
Correct.
And then did it ultimately land or strike somewhere and come to a stop?
Yes.
And where was that?
It's right outside the bathroom door.
So I'll show you states 9. Is this the frame of the bathroom door?
Yes.
And if you could just tell us what we see here.
It's going to be the projectile inside that hole.
And you marked that 11.
Correct.
This is states 10. What do we see here in states 10?
The trajectory rods, just to show the path of the bullet.
So those are something you placed there to make sure that was the same bullet that went through those holes at number 7 and 8, 9, and 10?
Correct.
And did you ultimately dig the projectile out of tent marker 11?
Yes.
And I believe states 11 is a close-up of that hole prior to your digging it up. Is that correct?
Yes.
And then what do we see here in states 12?
That's the bullet that I dug out at 11.
Thank you. Did you find any other holes anywhere else in the home?
Yes.
Okay. And where was that?
The living room.
And did you document that?
Yes.
I'm going to show you states 13. Can you kind of orient us in the home? Or if I can switch back to the floor plan if it would help. But.
No, that's the front door by 16. So it's like right in the living room area.
And now that wall that we're looking at, is that, I see a window, so that's an exterior wall of the home?
Yes.
And where would the bedroom be in this photo, or not in this photo, but where would the bedroom be comparison to where this photo is taken?
Behind me.
And what is this small brown item? I believe we see it in states 14.
It was struck by the bullet.
And it's some kind of canvas thing.
Yes.
So this is states 14. And then states 15, is that the bullet that traveled into the living room wall?
Yes.
And you collected it?
Yes.
I'm going to just go back to states 3. If you could kind of show us on this diagram where that bullet strike was.
It would have been right here.
So that's the door we saw and the window we saw in the
Right.
corner of.
Yes.
Thank you. Did you find and collect any other firearms in this home?
Yes.
And how many?
2 others.
And where were they located?
One was in the bedroom with the blood, in the closet, in a backpack.
And so I'm showing you state 16. Is this the closet you're talking about?
Yes.
And where's the backpack?
Right there.
And then I believe state 17, is that the firearm in the backpack?
Yes.
Thank you. You said you found 2?
And then one was in the kitchen pantry.
And I'm showing you states 18. Is this a portion of that kitchen pantry?
Yes.
And where was the firearm?
It was below that picture. Yes.
And so we see a basket here, and then this is another
That's
basket.
when, yeah, that's when, yeah,
And so states 19, that's a firearm.
correct.
Okay, and you collected both of them.
Yes.
Ooh.
Were they both loaded?
Yes.
Did you locate any cell phones in this home?
Yes.
And did you collect them?
Yes.
I'm going to show you what's been marked as states 20 and through 22. Judge, these are entered by stipulation number 2. But are these photos you've seen before?
Yes.
And is it your understanding that they were taken by first responders when the victim was still on scene?
Yes.
And I didn't ask you, but when you arrived, had the victim already been taken away by EMS, to your understanding?
Yes.
Were you ever given any information by law enforcement to help you in your investigation about why there was a drag mark?
Yes.
And what was the information that you were given?
They had pulled him out to start working on him.
And is it your understanding these pictures were taken in the bedroom prior to that?
Correct.
Your Honor, the state, they were entered by stipulation, but the state would ask to publish
All right,
20 through 22.
ma'am, can I please have
Oh,
20 to
I'm
22?
sorry.
I have them here if you want on the screen or not, either which way.
I can look at them here.
Okay, thank you.
Okay.
On the night of the incident, did you have any involvement with the defendant, Ms. Benefield?
Not that night, no.
And was it your understanding that another crime scene tech took photos to document her appearance on that night?
Yes.
And who was that?
It was Megan.
And Your Honor, I believe these are entered by stipulation number 4, but Ms. Conlon, would you take a look at states 23 through 26 and tell me if those are the photos you understand? It's Megan Dvorak, is that
Correct. Yes.
she took those?
Yes, these are Megan's pictures.
And Your Honor, the state would ask to publish them. Would you like me to do it on the screen or would you like to just look at them?
Let me just reach into it. Oh, gosh. Just to confirm, there you are. 20 to 22 and 23 to 26 are stepped in.
Yes.
All right, they'll be received.
Thank you, Your Honor.
So because he was taken away by the EMTs before the
And
crime scene tech got
Ms.
there,
Conlon,
they're-
later, were you
I guess
asked
she won't be
to,
introducing
document
gruesome
Ms.
images,
Benefield's appearance
most
again?
likely.
Yes,
And do you recall what date that was?
it was the 1st.
Of October?
Yes,
And where did you go to do that?
at the sheriff's office.
And did you in fact take photos of her?
I did.
I'm going to show you states 27, 28, and 29.
Yes,
And are those the photos you took of her on October 1st, 2020?
yes,
And do they appear to fairly and accurately depict her appearance that night?
yes.
Your Honor, the state would ask to enter 27 through 29.
Any objection?
None, Your Honor.
Received?
And while you were there, did you observe any injuries to her body?
Some scratches, light bruising.
And this is 27, is that taken October 1st?
Yes,
And then this is 28, are those the scratches you were talking about?
yes,
And 29?
yes.
Did Ms. Benefield complain of any injuries to you that night?
She never spoke.
Thank you. I don't have anything further, Judge. The defense may.
And Judge, I just want to correct something before the defense does cross. The picture that came in as State's Exhibit number 2, it was my fault. I switched the pictures on accident. That firearm is the one that was found in the backpack in the closet, not the one that was found in the neighbor's house. But all the testimony about the neighbor's house and the gun being at the neighbor's house is accurate. It's just the picture is a different gun.
Oh,
Okay.
so
And are you
she
getting into
apparently
the
ran
pictures?
to
Do
the
you want
neighbor's
lights
house
back
right
up?
afterwards
I think
to
for
tell
right
him that
now,
she
we'll
had
just
shot
lights back up, Your
her
Honor.
husband.
I
Absolutely.
may request that they go down.
Just let us know.
Do you want the hard copies?
Jack. Deputy Conlon,
I'm not a deputy, just as a crime scene tech.
crime scene tech. How shall I address you, Miss Colon?
Yeah, that's fine.
I have a few questions for you. No heavy lifting. I first want to ask you about crime scene.
Mhm.
Your purpose as a crime scene technician is to arrive and document as accurately as possible the circumstances that you find.
Yes,
And traditionally, ideally at least, you should be the first one that enters the crime scene, if you will, so that what you document is an accurate depiction of how it existed at the moment.
correct.
All right. In this instance, that wasn't particularly possible, correct?
Correct.
Because he had already
All
been
right.
taken away.
And in fact, before you arrived, Douglas Benefield, who subsequently was deceased, he was moved in an effort to be worked on by not only the deputies on the scene when they first arrived, but by the EMS people as well.
Yes,
All right. So in your documentation of this scene, anything that might depict certain things could have been modified based upon prior efforts inside the crime scene.
correct.
Now, you told us approximately, I realize going from memory is difficult. Did you write supplementary reports?
I did.
Okay, do you have them with you today?
I do.
Good. Can you tell us approximately Feel free to refer to your notes if necessary. Can you tell us approximately what time you arrived on the scene?
Approximately, it was 8:28
8:28
in the evening,
in the evening,
Correct.
PM.
PM, yes.
And your reports, Ms. Colon, would they document what time the incident was reported or alleged to have occurred?
Not in my report, but I had the notification time that I was called, which
Yeah.
was going to be 19:37, which is 7:37 PM.
7:37.
Correct.
Okay. And would it be fair to say that notification to crime scene goes out pretty much immediately?
Correct.
All right. Because once again, you want to be first on the scene to be able to preserve it.
Correct.
Okay. So in this case, assuming that the incident occurred sometime close to 7:37, you arrived approximately an hour later.
Correct.
All right. You said something in your direct testimony that was interesting. You had entered the residence pursuant to a search warrant.
I have to wait for the search warrant. The residence I entered was the next door neighbor's residence
Yes.
to collect the gun. But
Yes. But for purposes of the incident where the shooting took place, you entered after being notified that the search warrant had been secured.
correct.
Okay. So this is what I want to establish. If you got notified of this incident at 7:37 and you arrived and entered at approximately 8:28, approximately an hour later, somewhere in between that time, a search warrant was drawn up and provided to a judge who signed it to allow you to enter.
Correct.
That's some pretty fast work, no?
That's pretty typical for our agency.
Okay, so in other words,
They're pretty used to writing them pretty quick.
okay, so the incident happens, bing, bang, you put the search warrant together and you're in.
Yes.
Okay. Now, just so we're clear and there's no confusion, and I don't mean to imply in any capacity that there was any sleight of hand involved. The actual weapon that was pictured in the slide was the gun that came out of the backpack,
Correct.
which I think is a Sig Sauer
The
Oh.
backpack was a 380, yes, 6 hour, I believe.
380,
It was a 380 in the backpack,
right? Not the 45.
not the 45.
Okay. And the photographs that were taken of Miss Benefield, some were taken that evening, correct?
Correct.
And then there was another opportunity to take a second set of photographs a couple of days later on October 1st.
Correct.
And why would there have been a second set of photographs taken on October 1st?
To see if any more bruising would come up, better pictures.
Yeah, in other words, a lot of times bruises are not readily apparent immediately and they develop over the course of a day, 2, 3 days.
Correct.
Okay. Now, give me just a moment, please.
Debbie Faison Cook, thank you so much for your super chat. Very kind. I'm trying to pull this on the screen. If this goes to trial, can they still use self-defense or will they have to come up with something else? This is a good question. They will still be able to use self-defense. They will still be able to use essentially all the same arguments, but the state will have a higher burden to prove their case.
Okay.
So, because right here, the state only has to show by clear and convincing evidence, and the at trial, the state has to show by beyond reasonable doubt. They have to show that the she murdered him and was not entitled to any sort of self-defense beyond reasonable doubt. So yeah, she's still entitled to the defense. She's just trying to
All right,
use
Ms.
this
Colon,
opportunity
I wanna
to get the
ask
whole
you a
case
few
dismissed, not have to go to
questions
trial
with
at all.
the help of my very able-bodied assistant, Mr. O'Keefe. And we're going to put a few of those photographs up. I want to ask you some questions about them.
If you're going to refer to any that are already in evidence, I prefer we use the ones that are already marked. If there's additional ones, then obviously you can lay the predicate or get a stipulation for admissibility.
I just want to see.
Let me answer another question if we are kind of waiting here. Maya Johnson, is there not an insanity plea in Florida? There is. They are not using it though, because probably because there are certain requirements that have to be met. You've got to meet a number of elements. And so even if she's cuckoo for cocoa puffs, cuckoo for cocoa puffs. I need to get my references straight. Even if that's the case, that doesn't necessarily entitle her to an insanity plea. Marvin, so the gun thing was before the marriage. Apparently so, which doesn't necessarily mean that there wasn't abuse, right? We've seen situations where people, where people have a hard time
23 through 26,
leaving
those are
someone.
here.
All kinds of ways that there could be psychological control, but
These are photos of Miss Benefield.
it's still a question worth
And my notes
investigating.
reflect that 23 through 26
It could be
are
that there's no
photos from
abuse.
the night of the incident.
Yes.
Okay.
Thank you.
Gwendolyn SS question is, so if it's determined that stand your ground doesn't apply in this case, can we start thinking that the following trial will be a foregone conclusion of her being found guilty? Not necessarily. I mean, maybe it takes weighing the evidence, right? One of the reasons why I think the judge is likely to not grant dismissal for the defense, why the state is likely to win this hearing, is because judges typically don't like taking cases away from the jury. So it takes a lot for that to happen. And this might be a little bit of a gray kind of area here, that the judge is probably going to say, no, we need a jury to hear this one. And remember, there is a different standard. Like I mentioned a few minutes ago, there's a different standard for this hearing than there is for trial. So the state here has to show by clear and convincing evidence. At trial, state has to prove their case beyond a reasonable doubt. No reasonable doubt. So if your common sense says she probably was being abused, or she had a reasonable belief that that her life was in danger, then and the thing is too, is that, there's other factors as well. The tendencies of female defendants in these kinds of cases tend to do
Good.
relatively well, especially when they are
All right,
attractive,
Ms.
as she
Colon,
is.
let me
Doesn't mean that
direct
it's a
your
foregone conclusion in her
attention
favor
to
either.
the exhibit
But those are
that
factors
is
that
now
could
up on
play a
the
role.
Elmo. I want to ask you, with respect to Miss Benefield's left side of the face, specifically the left eyelid, does that appear to be the same size as the eyelid on the right, or does it appear to be swollen?
Objection.
Yeah, I'm going to sustain. I mean, I can see that for myself. I don't need the witness to narrate what the evidence is, unless there's something specific that you want to draw out about it, but.
No, that's fine. The only other question I was going to ask was about the left cheek, Your Honor.
Okay, but I also think that she didn't take these.
I understand.
Okay, go ahead. So I'm going to sustain.
Yeah.
Okay. With respect, Ms. Colon, to Ms. Benefield's left cheek, do you see that as swollen as compared to the right cheek?
Sustained.
All right. Next.
Kate Eliza, by the way, I see your member chat. Dang it, I'm late to court. My apologies, Your Honor. No worries.
This
Just hit the
was
like
a
button.
photograph
Then
that
you're all
was
good.
taken when?
That was the first night.
Okay. And this was taken by you?
No, that was taken by Megan.
By Megan. Are you familiar with this photograph?
I am.
All right. Does this photograph, it's hard to depict in this exhibit under the Elmo.
Yeah, I don't really see anything.
Does it show whether or not the scratch?
Objection, Judge.
Yeah.
Well, I understand, but let him finish the question. I don't know where he's going. It's not uncommon for lawyers to start this way and make a, not wrong turn, but left turn. So
I'll
go ahead.
withdraw the question.
Oh, no, ask your question, please, but I don't know
Yeah.
where it was going.
I understand, but I also know what the ruling is, so.
If it's
yeah.
just to narrate
Out of
what's,
concern for the court's time.
yeah,
I
I
understand.
mean, and then you can
Withdraw.
argue that certainly,
I'll be able to argue it. too.
absolutely,
Yeah.
100%.
Okay, thank you.
Redirect?
Yes, briefly. Ms. Conlon, in your many years at the sheriff's office, you've responded to homicide scenes regularly.
Yes.
And is it your understanding from your experience that a lot happens prior to your actually getting called out?
Yes.
And so if you get a call out at 7:37, you can't say how long law enforcement had been on scene prior to your getting there, can you?
No.
Because in theory, patrol arrives first.
Correct.
And at some point, there's a determination that there's a homicide before the homicide unit gets called out.
Correct.
And are you next in line after the homicide unit?
Yes. Yes.
And you're not the person writing the search warrant. You just wait before you enter.
Correct.
Thank you. Nothing else, Judge.
Sir? All right, can this witness be released, state?
Yes.
Mr. Taylor? All right, maybe you're releasing your subpoena. Thank you very much.
All right. Next witness.
Oh, yes.
Scottish Jason, question, was this bald lawyer the prosecutor in the Cruz trial? Seems
Oh,
familiar.
oh, well,
I
hold
don't
on then.
know, 'cause I
All right,
actually
ma'am, apparently you're still
didn't
under
follow the
subpoena.
Cruz trial that
All right, so
closely,
remain
other than
available.
some
Thank you.
highlights, mostly about the judge. So
Go ahead.
The state call.
something
Dr.
tells me he's been a
Vega.
defense attorney for a while, though. He seems very experienced. And I totally missed her name. I'm sorry, guys.
Oh,
I'm gonna have to
let me check real quick. Ms.
I'm gonna go
Sarah?
back real quick.
Dr. Vega.
Dr. Vega. Okay.
Oh, you know what? Let me check real quick. Ms. Sarah, how are you doing?
I'm doing fine, thank you.
All right. If you need a break, you let me know.
Appreciate it.
So for those who are new, new in the chat or new watching, I know that I see that the numbers have been rising, which is always wonderful to see. And if you're not really familiar with what's going on, so this is not exactly the trial. This is I can just talk over them, I think, right now.
I can see right here.
This
I-
is
I will-
a
I'm not gonna
hearing
get in the way of
on
you
whether
presenting
or
your
not the
case,
defense
but
can
I'm fine if
have
you
this
want
case
to
dismissed on
put 'em on the
a
overhead. I'm
privilege.
fine if
In other
the
words,
witness is sitting
stand
right
your
here,
ground.
And
also,
Mr. Taylor could approach as well
another
and
question here that
see
came up.
exactly where things are being pointed to without putting up the
So
photos.
stand your ground. Melissa
Either
Gender,
way.
thanks so much for the question. Sorry if this is a silly question, but what does stand your ground mean? It's essentially self-defense.
Just to remind.
She
Your
has to
Honor,
show-
We have the Daubert motion pending as to this witness.
Correct.
Do you solemnly swear or affirm the testimony you're about to give in
Okay.
this case to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
One sec before he testifies. So stand your ground means it's self-defense. So what she is arguing is that she had a reasonable fear for her life and that she used the requisite force in order to defend herself. She has a number of allegations that she made over a period of time of domestic abuse, threatening, psychological sort of abuse. She also claimed that he had been poisoning her with heavy metals, which, there was a lot of discussion in the chat about the fact that there were no doctor's records. She didn't go to a doctor to make complaints about that. There's nothing that shows up in her medical records. But for me personally, I look at that as, when you are pregnant, you're generally speaking seeing a doctor way more often than you might be otherwise, because you are having regular checkups with a doctor. And so what I would like to see is some kind of testimony that she was seeing a doctor during that time, and she was, getting these regular checkups, and that there was nothing showing up in her blood, or nothing showing up in any of her vitals showing that she was, being poisoned in any way. That's what I would want to see from the state's perspective, because they have basically said, like, she didn't make these claims to anyone else. She just made these claims, during this custody dispute after the baby was born. And this is kind of a wild case already so far. If you guys want some more details and you don't know anything about it, there's some more in the description below, talking about how they met, and then 13 days later, 13 days after meeting, they got married. He had just recently been widowed from his first wife, who died from a heart condition. He had a teenage daughter at the time that was also living with them. There's no allegation from the daughter from his first marriage of any kind of abuse. The defense, on a cross-examination of a witness previously, made a suggestion that the first wife, Renee, that there was some sort of an allegation of abuse. We don't know if that's real or not. It's been suggested. But it does appear that he had some kind of anger issues. He punched a wall at one point. He fired a gun at the ceiling. I don't know. It's from what I've been paying attention. It seems like it's disputed whether that was intentional or not. But the judge in the family case, in the family law case, the judge basically looked at all of the defendants' complaints about the decedent, about the alleged victim. State is using the word victim here, and murder, which is likely not going to happen at trial, because that's very prejudicial. But because this is in front of a judge and not a jury, there's arguably more flexibility with those terms, because the judge is not going to be prejudiced in the same way that a jury will with those kind of inflammatory kind of terms. So I don't knock the state for using them, although it's like I'm so used to just not using them in a courtroom, because usually we are watching an actual trial here with a jury. So anyway, so the judge in the previous the previous custody battle had said that all of the complaints that Ashley, the defendant, was making against the decedent, Doug, were completely false. She used the phrase, "not a scintilla of truth," not a single chinchilla involved here, guys, according to what the judge said. And she considered the gun shooting in the air. She considered the wall punch. She basically said those were all few and far between. He wasn't pointing a gun at her. He wasn't punching at her. So the judge considered those things, and that was her determination. Whether you agree with that or not is maybe another story, but it's all very, very, very fascinating. Scott J, thanks so much for your super chat, says, if she is successful in this hearing, can she still be tried later if there's new evidence, or does double jeopardy apply? Oh crap, that's a good question. I think probably double jeopardy would apply, because you're still, yeah, I think double jeopardy probably would apply. But if there's another person that is even better versed in criminal law can correct me on that, I will totally take a correction. But I think it would, because I think that would be a final determination on the case. Okay, all right, let's continue on.
Well, Dr. Vega is sitting down. The way I read the motion was specific to one particular injury.
Correct.
So let's do this. When we get to that point, and please feel free to disagree if you want. I think when we get to that point, object, so it's preserved. You have your contemporaneous. Let the testimony finish, then you can cross on that. And then whether if I let it in, it's all there. And if I agree with you that the foundation hasn't been laid, or it's otherwise not admissible, then it's still proffered and it's in the record. Would that be okay?
Yes, sir.
Okay. Hello, sir. Make yourself comfortable in the chair, 12 to 15 inches from the microphone. Loud, clear voice will pick up everything, and it does adjust up, down, left, right. Thank you.
Thank you, Your Honor.
Good morning.
Good morning.
Please state your name
My name is Russell Scott Vega. The last name is spelled Vega.
and where do you work?
I'm the Chief Medical Examiner for the 12th District of Florida,
Medical
and that
examiner.
includes Manatee County, where we are now.
Okay,
And what is
now
the
we
12th
might get
Circuit?
some gruesome images. Just
It includes
forewarning.
3 counties, Manatee, as well as Sarasota to our south and DeSoto County to our east.
And you said chief medical examiner. So what does that mean?
That means in the medical examiner's office, I supervise the other medical examiners. I set policy. I basically manage the office.
You're the boss.
Yeah.
Okay. And what is your education to do the job that you have?
I started in undergraduate, majoring in physics and biochemistry at Florida State University. Then I went to medical school after that, University of South Florida in Tampa. After medical school, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology, and then a year of subspecialty training in forensic pathology.
Hold on one second. I'm sorry.
Your Honor, out of respect to the court's time and to Dr. Vega, whose credentials I'm familiar with, we're happy to recognize him.
All right. Do we willing to stipulate or accept that stipulation?
Yes, I do have a few more questions about specific things that he's done though.
Okay.
Okay. And how long have you been the chief medical examiner, if I didn't ask you already?
It will be 20 years, October 1st.
Okay. As part of your duties as a chief medical examiner, do you still perform autopsies and do the work that your other medical examiners would do?
Yes.
How often would you say you perform autopsies?
I'm on the schedule every month, so not necessarily on a weekly basis, but certainly on a monthly basis.
Okay. And over your career, how many autopsies would you say you've done approximately?
Yeah, I don't have an exact count, but probably in the 3,500 to 4,000 range.
Okay. How many of those approximately would you say are gunshot wounds or contain some aspect of a gunshot wound?
It's in the hundreds, but I wouldn't be able to tell you more than that.
Is wound interpretation part of your duties as a medical examiner?
Yes.
Okay. And what exactly is wound interpretation other than exactly what it sounds like?
It's being able to examine a body and identify injuries present on or in that body and be able to, in that identification, determine what the nature of the injury is, possibly what kind of implement, tool, or weapon was associated with inflicting that injury, and other things about the nature of the injury, such as when it occurred, or things associated with the circumstances under which the injury was sustained.
Okay. Did you do the autopsy of Doug Benefield?
Yes, I did.
And when was that?
That autopsy was on September 28th of 2020.
So the next day.
And generally on Mr. Benefield, how many wounds did you find?
I found 2 clear gunshot wounds, 1 possible gunshot wound, and then 2 other separate smaller injuries, 1 to the head and 1 to the back of the thigh.
Okay. Were pictures taken during this autopsy?
Yes.
Okay. I'm going to show you States Exhibit 30 through 38. You can just take a look at these.
Ink and caffeine. This is a hearing for the murder
Oh, 'cause
case.
I think it's set to that.
So we're not exactly at the trial just yet, but it is for the murder case. So assuming that the state wins this, it should proceed to trial unless she negotiates some kind of a deal with them.
Do you recognize those?
I do.
And what are they?
These are photographs that were taken at the time of the autopsy of Mr. Benefield.
And do they accurately reflect?
Ashley Boyer, these are fair
the
points.
autopsy as you recall?
Entirely fair points.
Yes.
The judge could have gotten it wrong.
Evidence states 30 through 38.
Objection?
No.
Received? Are you going to publish them now?
Yeah.
Okay. Get ready, guys. Trigger warning.
The state is about to publish photographs that were taken during an autopsy. I would imagine that most people here probably have never attended an autopsy or seen photographs
Not
from an
fun.
autopsy.
I can tell you from personal experience.
I don't think, I didn't see them, but I don't think they're the full autopsy.
No.
I would assume they're external
Yes.
photographs.
Yes.
However, for those of you who may have an emotional connection with this case, sometimes these can be very difficult to look at. So if you think that you might have some difficulties, I'm not worried. Sometimes I'm worried about a jury and an emotional response. I'm not worried about that. But just to avoid any distractions, if anybody thinks that they might have an reaction, please feel free to step out for a few minutes and then we can step right back in. All right, go ahead.
Thank you. I'm going to show you State's Exhibit 30 just so we understand who we're talking about. Is this the patient, Doug Benefield?
Yes, this is a photograph of the decedent,
The decedent.
Mr. Benefield, from the essentially mid-chest up.
Okay. And I'm going to show you the next exhibit, State's 31. Can you tell me what we're looking at here?
Yes, so this is the decedent's right arm and the right side of his chest. And this shows two injuries, really one superficial injury to the right arm. And I can use the laser pointer if you like. Okay.
Judge, this is the wound that's the subject of the motion.
Understand, I'm going to reserve on the objection. And once I hear it, then I'll make a final ruling. But yes, noted.
So we see two injuries here, one on the chest here and one on the right arm. The chest really is a more complex injury. There are really three components here. There is what was circular gunshot perforation here. There is an incision that was made by doctors who were treating him in life-saving measures that was made from the edge of the gunshot wound downward here. That was to insert a chest tube or tube to relieve pressure and blood from the chest cavity.
And I didn't ask you this, but sometimes people are pronounced deceased at a scene, and sometimes that happens at the hospital after medical intervention. And I think you've answered this, but which type was this?
This was the second type.
Okay.
Yeah,
So he had signs of medical intervention.
he did indeed.
And are you trained to identify that as opposed to an injury?
Yes, I am.
Okay. You can go ahead. So the top of that chest wound would be the bullet, more of the bullet entry wound.
That's right.
Okay.
That's right.
And then, go ahead.
In addition to that, there's also, there is some bruising that's evident in the skin around that hole. And then separate from that is the arm wound here.
Okay. So let's talk specifically about the chest wound first.
Yes.
So this wound, I don't know if you said it first or if I said it first, was an entrance wound. How do you determine the difference between an entrance wound and an exit wound of a firearm?
Well, there are characteristics of the hole in the skin itself that can be helpful in that regard. But the easiest way to be able to tell the difference between an entrance and an exit is if you have one hole and the projectile still in the body and you have a track between those 2 points.
Okay.
That's what we have here. So
Okay.
that helped me be very confident that this was an entrance wound.
That's
If you
the
have-
entrance wound.
If you have two
so-
holes and no projectile. Usually it's pretty clear, but it can be a little bit harder.
Okay. But in this case with the chest wound, was not difficult.
That's correct.
Okay. So this is State's Exhibit 32. It's a closer up image of the chest wound. Can you just point out where the bullet injury would be?
Yes, that's right here.
Okay. And then State's Exhibit 33 is the back of Mr. Benefield, and there's a lot of discoloring the top of the shoulders and the lower back. What is that?
Yes, so you're correct. This is his back, and for clarification, this is the neck and the back of the head, the left ear, and there's this pink purple discoloration here, but especially up here on let's just say the shoulder regions. That's lividity. Lividity is the pooling of blood that occurs in the body after death. That part of what we see is not injury or in any way related to what happened to him prior to his death. It's
Okay.
simply essentially what we would call an artifact or a postmortem finding.
Okay. So this is the darkness that we're seeing here is just sort of a natural process.
This here
Mm-hmm.
and this here.
Okay.
That's correct.
And what about this picture is not a natural process?
Within this area that's not discolored, and the reason for that is that there was pressure on the skin here that prevented the blood from pooling after death. So that's why it's more pale. But in the at least contained within that zone is this smaller, darker purple area. And that is not lividity or a postmortem finding. That's associated with injury.
Okay. Did you inspect that area to find out what it was?
Yes.
Okay. And what was it?
I could palpate, I could feel a lump under that area of the back. And upon further examination by cutting the skin and examining underneath, there was a projectile there.
Okay. So I'm going to show you States 34. What are we looking at here?
This is a photograph that was taken after I had done the incision and essentially uncovered the projectile that was in the subcutaneous tissue, the tissue under the skin.
Okay.
And that's the projectile right there.
And during the autopsy, were you able to connect the path of the initial hole to this projectile?
Yes.
Okay. And if you could just explain what it went from which side to which side?
So referring back to the photograph, if you will, we don't have to show it, but it was on the left side of the back, and the entrance wound that we saw was on the right side of the chest.
Okay.
So the path that the bullet took was across his chest from right to left.
Okay.
It was also somewhat from front to back.
Okay.
In considering a standing position, it was horizontal, roughly, meaning that the entrance wound was at the same height
So he
above
wasn't
the
shot in the
ground if
back.
you were standing that the bullet was found. So there was no significant upward or downward trajectory through the body.
Okay. So on that plane, it was fairly horizontal. It didn't go up or down much.
Yes.
Okay. So I just want to, I can either do it on myself or you can do it on me. So, or I can do it on me. Point to
Did I
where-
mishear that? Did he say it was somewhat starting from the front to go to the back?
So on me, the entrance wound is basically where I'm pointing now.
And then the exit wound or where the projectile landed would be where?
Back here. I
Okay.
probably can't point quite as accurately on myself there, but
Okay. So there was a definite right to left
definitely,
motion of this projectile.
definitely a right to left trajectory
Okay.
through his body.
So the next photo I want to show you is State's Exhibit 35. This is a different wound. This is the arm wound.
I'm
Can
sorry,
you tell?
This is the arm?
Yes, this is the arm.
Yes, sir.
All right, reserved.
And what can you tell me about what we're looking at here on the arm?
So the arm wound is a superficial wound. It's essentially a scrape of the skin. So the surrounding skin is normal, right? And then this area, the the superficial part of the skin, what we might call the epidermis, and maybe a little bit of the skin underneath that, of the dermis underneath that, has been scraped away, and it leaves this red, irregularly shaped wound here.
Okay. And you said relatively superficial. So what does that mean?
That means that outside of the skin being scraped away, there's no deeper injury, there's no additional damage, there's no underlying injury to the bone or the soft tissues, there's no bruising. It's just this scraping of the skin, and that's it.
And being that it's superficial, does that limit your ability to determine where it came from or what it's from?
In this case, I would answer that yes. In general, sometimes the pattern or the nature of the appearance on the skin can give you a very clear idea of how that injury occurred. But in this case, it's a relatively irregular and what I would say not characteristic of any particular mechanism of injury.
Okay. If you had to make an educated decision about what you think this is, what is your opinion about that?
I think more likely than not, it is a.
I understand. I'm sorry, just, we have to get objections on the record. I'm
Sorry. Go ahead.
Certainly.
Reserved.
More likely than not, it is a what I would call a grazing gunshot wound. Grazing gunshot wounds are wounds that just barely scrape across the skin in their path rather than going into the body. And so they leave a scrape pattern on the skin where they do that. Grazing gunshot wounds sometimes, frequently, have a much more characteristic appearance, and this one did not really have those characteristics. But given that we have 2 clear gunshot wounds in the body, and this additional injury could be, by its appearance, a grazing gunshot wound, I think it more likely than not that it is.
Okay. And you said it's not typical of a graze wound. What do you mean by that?
A typical grazing gunshot wound looks like a furrow or a trough across the skin. It's long, narrow, and typically it has characteristic shapes at either long end and has skin tag tears along the long edges, if you will. And this really didn't have any of those characteristics.
Okay. So that made it difficult to determine exactly what it was.
Yes.
Then I want to move to the leg wound. This is State's Exhibit 36. If you could orient us, what are we looking at here?
So this photograph is taken with the leg turned, and you're looking at the back surface of the leg. And when I say leg, I'm referring to the calf. So the part of the lower extremity, which is below the knee. So this is essentially where the knee is here.
Facing away from the camera is where the knee would be.
Correct, and behind the gloved hand. So this is the back of the calf, and the body here is turned over. So it makes the orientation a little bit more, I'm sorry, the leg is turned over, so it makes the orientation a little bit harder to see.
Okay.
But this is the back of the right leg, and the injury itself is, the hole here that's between the 2 parts of the ruler.
I'm going to zoom in on this. So if you could tell us, can you tell, first of all, is this a gunshot wound?
Yes,
And is this an entrance wound or an exit wound?
this is an entrance wound.
And how you tell it's an entrance wound?
Okay.
An
That's from the
entrance
back.
wound typically has a round or oval shape based on whether or not the projectile is going into the skin from a perpendicular, straight on orientation or at somewhat of an angle. The angle creates the oval shape typically. And this is an oval shape here. It has some scraping or abrasion at the edges of the wound here. And those characteristics are typical for an entrance wound.
Okay. So you mentioned oval shape is indicative of a projectile coming at an angle.
Yes.
So that would be as opposed to maybe from side to side of the calf, it is at some sort of an angle.
Well, it could be side to side as a comparison, but the main thing is to think of it as not being at a perpendicular angle to the skin. So that angle, you could have an oval which is horizontally oriented because the angle is like that to the skin.
Yes.
Or you could have an oval which is vertically oriented, like this one is, because the angle is up and down, related to the skin.
So with reference to this entrance wound, assuming someone were standing, so that would be the normal anatomical positioning?
Yes.
Standing? Okay.
Yes.
So the angle of this entrance wound would be coming from which direction? Coming from where?
From below the level of where the hole is. So it would be coming from essentially the floor.
Okay. So if someone were standing and someone were laying on the floor, they could shoot up and maybe get this angle.
Yes.
We're not saying that's what happened. It could happen.
Yes.
Okay. So I'm going to show you the next, which is States, oh, I have to close it. States Exhibit 37. What are we looking at there?
So this is the right leg seen from a different perspective. We were looking before at the right leg twisted from the left side of the body. Now we're looking at the right leg untwisted from the right side of the body.
Okay, so when you say twisted, as we're looking at that leg now, when you took the picture before, twisted this way, you mean?
Yes. And
Okay.
Let me.
You could show.
It was rotated like this.
Perfect.
So that you could see the back of the leg.
Thank you. So now the leg is flipped back, and what are we looking at here?
So this is the right knee here. This is the right leg, right foot, and this is the exit hole for the gunshot that started with the entrance that we just saw previously, and that's just below, but basically on the side of the right knee.
And I have one more picture, a little closer up of this. So well, let me back up a minute. Where would the entrance wound approximately be on this picture?
So the entrance wound is back here at more or less this level, where we can't see it because it's on the underside of the leg. And even if this rail were not here and you could see the entire leg, you probably wouldn't see it because it's on the back of the leg, not the side.
Okay. And then the last picture that's a little closer up, I just want to ask you, how can you tell that's an exit wound?
As opposed to the previous entrance wound that we saw, which was an oval hole, this looks more like a tear in the skin, and that is characteristic of exit wounds. This tear is irregular and V-shaped. Exit wounds tend to have non-predictable, irregularly shaped tears in the skin, and this is pretty common appearance for an exit wound. And as I described previously when we were talking about the chest wound, being able to pair two holes together, the sort of features that make one hole an entrance and one an exit are amplified when you see the two together, and one is characteristic of an entrance, the other is characteristic of an exit. That makes it a much more certain determination. Sometimes you have two wounds, both of them can look more like entrances, and then it might be hard to tell which is which. They might look more like exits, depending on individual characteristics in that particular case. But in this case, pretty straightforward. The one we previously described looks like an entrance. This looks like an exit, so that's the pairing.
Okay. And the path went straight through.
Yes.
Did the projectile hit bone or was it just tissue?
It did hit bone.
Bone, okay.
Yeah.
So if you could just verbally say, what was the directionality of this wound path?
So this wound traversed the leg in an upward angle from the back toward the front and also from the left toward the right.
Okay. So are you able to, let's assume that there were 3 shots. Let's assume that one's a graze wound. So one shot was found inside the body, one went through and through the leg, and then there was a graze wound. Are you able to say which one of those happened first?
No.
And why not?
Sometimes wounds that are in the same part of the body, especially say gunshot wounds through the head, the fracture pattern can tell you that. But if you don't have something like that, there aren't physiological features that allow you to time them unless there's been so much time between that there's healing, for instance.
Right.
So there was none of that here.
Okay.
So there were just simply no physiological findings that would allow me to tell which came first.
And also, do you have limitations on being able to ascertain where the shooter was versus where the victim was when shots were fired?
Well, one thing that being able to determine an entrance and an exit through the body, or in the case of the chest wound, the entrance and the location of the projectile within the body, it allows you to determine the relative position of the gun when it was fired relative to the body of the decedent.
Okay.
So that gives you some of that information, but not all of it, because a gun can be held in different ways. It can be held toward the body or away from the body. It can be held at different heights and locations relative to the shooter. So some information, yes, but not. It doesn't allow you to tell you entirely where they were relative to one another.
If it can tell you where the gun is in relation to where the body is, it doesn't necessarily tell you where the shooter's body was positioned, only that the gun must have been at this angle. Is that what you're saying?
Yes.
Okay. So it's kind of confusing. So let me give you an example. We'll talk about the leg wound. It was right leg, correct?
Correct.
And it's going from here out here.
Correct. Yes.
At an upward angle.
Yes.
So if I were to be standing here, someone would have to be on the floor.
Right.
To shoot up my leg, right? At that angle.
More or less, yes.
Okay. How about if I were falling this way and someone shot? Could that angle be duplicated?
Yes, especially if you fell backward and really externally rotated your leg out to present the back of the calf to a gun that might be firing well to your left.
And
So it could
is
be that
there
the first
ability
shot that was
to
kind of from the
work
side
where the
was knocking him down, and then
and
the other shots were on his
this
legs.
direction, and the shot comes from behind?
Yes.
Okay. One moment. Did you do any toxicology on Doug Benefield, on the body?
I took samples and submitted them to the lab for toxicology analysis, yes.
And were there any drugs or alcohol in his system at his death?
No.
I wanted to ask you a question about the chest wound. What organs did it hit, or what important things did it hit?
So the projectile path went through the chest wall on the right side, and then it hit the right lung. It went through the vertebral body or vertebral column of the spine. Did not appear to hit the spinal cord in that track. After passing through the spine, it then hit the left lung and then went through the chest wall on the left side to end in the tissues where we found it.
And do you think that type of injury would incapacitate someone immediately?
It certainly could. These things are, they're not, it's not easy to, and really accurately predict because different people have different responses to the shock of the trauma and the pain and debility that would occur immediately. But there was nothing about the injury that would absolutely cause immediate incapacitation, like an injury to the spinal, a clear injury to the spinal cord
Severed
would.
spinal cord.
Right. Or a severe traumatic brain injury, or maybe even a severe injury to the heart. Those things you typically would expect to have near immediate incapacitation from. This didn't have that. So potentially, could there have been some activity, some ability to take some purposeful movements or motions or things? I think it's possible.
Possible, but probably not likely.
Not likely to do a great deal. I think in my experience, most people who suffer injuries like this do fall pretty quickly from the place where they're shot.
Okay. And were you able to determine the cause of death?
I was, yes.
And what was that?
Gunshot wounds.
I determined the cause of death to be the gunshot wound to the chest that we've been describing, with perforations of the lungs and the medical term I use is hemothoraces. That's blood accumulations that are occurring in the chest cavities around the lungs on the right and left sides.
Okay. And I noticed that you didn't mention that you had mentioned earlier that there were a couple other injuries, one in the head and one, I don't remember where you said it was, but I noticed that those didn't play a part in that cause of death. What are those injuries?
So there was an injury to the back of the head, a typical scraping and bruising injury that we might see from someone falling and striking the back of the head.
Okay. So if he were shot and then did fall, it might do that to his head.
Yes.
And where was it located on his head?
Essentially what we would call the occipital protuberance, or the back of the head where I'm putting my hand now.
Okay. And what was the other injury you observed?
The other injury was a very minor injury to the back of the thigh, really barely noticeable. I don't really have an opinion as to what caused that injury, but it wouldn't have been anything that was debilitating or causing any problem, and certainly wasn't associated with the cause of death.
Okay. And is it possible that that injury was inflicted or he had that injury at a different time?
I mean, it's possible. I didn't see clear evidence of healing in that injury, but it could have occurred outside of the circumstances of the shooting.
Okay. So the cause of death was that chest gunshot wound. What was the manner of death?
Manner of death, I determined to be homicide.
Okay. Thank you. I have no other questions.
All
Mr.
right.
Taylor.
Cross-examination. So yeah, it doesn't sound like there were any gunshots that were actually in the back. So the reporting on that seems to have been maybe not
For my
accurate.
purposes, I consider your objections
Not exactly from the
to
front
the
either.
right bicep
It seems like it
wound
was
be
from like the
preserved,
side of the
even though I know
chest
you're going to
towards
ask
the
questions
back.
about it. I consider it preserved.
My guess is she probably shot him in the chest, from the side. And then as he's falling, legs can maybe come upwards. Other shots happen through the legs. That would explain the angle of her shooting, because otherwise it's like, what is she, John Wick? Like shooting from the floor, or that would suggest maybe from the defense perspective that he had struck her and she was on the ground and shooting from the ground.
Dr. Vega.
Good afternoon.
Nice to see you again. I have a few questions I'd like to ask you. I want to start, if I can, with
This is definitely a gray area,
wound to the chest.
it seems like.
Yes.
It's not a slam dunk for either side, in my opinion.
What made the projectile, otherwise known as the bullet, you said that the track of the projectile was from anterior to posterior, front to back, and right to left, correct?
Yes.
All right. Were you able to determine what caused the bullet to take the turn from right to left? Did it deflect off bone, a rib? Do you know?
There was no deflection. The trajectory of the projectile prior to entering the body did not change significantly in terms of how it passed through the body.
Okay. Now, if you were going to scientifically determine the trajectory of this bullet, which you've told us is front to back and right to left, you know from your examination that you recovered the projectile from the back of the deceased, correct?
Yes.
So you would be able to show scientifically the entry wound, which was approximately where the right below the nipple, and trace the path through the body.
Seems like he was very
where
uncomfortable
you
saying that
come
word.
to find the projectile
He like
lodged in the
hesitated
back.
for a second, which I understand why. I would hesitate
Correct?
as well.
Yes.
All right. And with respect to the wound to the leg, from the interior of the right leg, which exited the posterior, the outside of the knee, you showed us the entry hole and you showed us the exit on the outside of the right knee. Said that they were typical of these types of gunshot wounds, and you would theoretically be able to trace the path of the trajectory of the bullet from the entry to the exit, correct?
Not even theoretically. I mean, I was able to make that
As a
that
fact.
track. Yes.
Okay. And I think to add even more measure to it, a projectile was recovered that was tested that had blood on it that came from the shot to the leg.
There was a fragment of a projectile that I was able to recover from that path through the leg.
Yes.
Yes.
And if matched with the remainder of the projectile, which was in the room, it had a small piece missing, equivalent to the fragment that you recovered in the wound for the knee.
That's possible. I'm not aware of the analysis of the projectile that was in the room that I never examined.
Okay. Now, with respect to the wound to the arm, we don't really have any facts that we can lay out equivalent to the wound to the chest, for example, or the wound to the knee. Correct?
I think the observations are much more limited. There's much less data there to look at to try and make a determination.
Right.
Yes.
Which is why you can very candidly describe this as a probable grazing gunshot wound.
Yes, that's the terminology I used in my report.
Yes, because you weren't certain.
That's correct.
All right. And as you sit here today, you're not certain.
That's correct.
All right. So what allows you to conclude that it may be a grazing gunshot wound is your experience.
Yes.
Okay. Do you remember I had the privilege of sitting with you and taking your deposition?
I do.
That was testimony under oath.
Yes, sir.
All right. And we talked about the wound to the arm. And I had presented you with, I think, 5 medical authorities that suggested that these type of wounds are always difficult to determine, and you agreed with that.
I remember the discussion. I don't remember the specific number of people that you might have gotten opinions from or such, but yes.
But you would agree, as you sit here today, that they are difficult wounds to determine.
Yes.
Okay. And in fact, I had asked you at your deposition how you determined the nature of the wound, and you corrected me and said you hadn't really determined the nature of the wound, which is why you described it as possible.
Yes.
All right. I want to ask you a couple of questions, if I may, Dr. Vega, about homicides. Not all homicides are crimes, correct?
Correct.
True.
We have what's known as justifiable homicide, where, for example, a homeowner shoots an intruder at night in their home. Example of a justifiable homicide, correct?
Certainly could be.
All right. And we have excusable homicides, where a law enforcement officer, and arriving on a scene, encounters the perpetrator who has a weapon, and the law enforcement officer shoots and kills the perpetrator. That's excusable homicide.
It sounds like it could be, yes.
All right. Do the absence of defensive wounds, Dr. Vega, necessarily exclude aggressive behavior?
No.
Okay.
Yeah, no way.
So somebody could be the aggressor and still not have defensive wounds.
I think that's possible.
All right. It also does not exclude the aggressor being the one that initiates a confrontation, does it? The absence of defensive wounds.
No.
You told us, again, very candidly, that you cannot, at least in these circumstances, determine the order of the shots with any reliability.
That's correct.
You've previously testified, and I would assume it's your testimony here today, that the deceased was facing the shooter at the time that the chest wound was suffered.
Yes, although based on the right to left component of the trajectory, the weapon would have been to the decedent's right side.
Facing, but not directly.
Correct.
Okay.
Yeah. So not shot in the back, but not exactly shot point blank either.
Your autopsy report, you have it with you?
I do.
Okay. You might remember this off the top of your head in preparation for today's testimony. The examination was completed on September 28th, 2020, correct?
The autopsy was performed on that date.
Yes. The autopsy examination.
Yes, there are components of the autopsy, though,
Sure.
that were not done on that day. For example,
Toxicology.
and the microscopic examination. That requires tissues to be processed into glass slides, and then glass slides have to be delivered. And then I look at them when I have the opportunity. I add those findings to the other findings that I got the day of the autopsy, and that all goes into compiling the final report.
All right. And you signed off on the final report, did you not, on November 3rd, 2020?
I did, yes.
Okay. As the medical examiner, and you're the medical examiner for not only Manatee, but also Sarasota County, correct?
And DeSoto, and right now, Charlotte County as well.
Find yourself a little busy? Do you have a working relationship with law enforcement?
Yes.
All right. That's pretty much the nature of the position, is it not?
It is.
All right. Do the detectives and the law enforcement personnel generally wait to hear from you, or do they periodically check in and say, so what do we got, Doc? Do you have a tentative opinion that you can give me? Is there any of that takes place?
It depends on the nature of the case, but certainly some cases there may be no communication at all until our final report comes out. In other cases, there may be discussions at various points during the evolution of the case from the autopsy to the final report. It very much depends on the nature of the case, the needs of law enforcement, et cetera.
Sure. So for example, like a poisoning allegation, that may be something that you're not in a position to give any kind of tentative opinion until the toxicology comes back.
That's possible. Yeah.
All right. And a
Kurt?
shooting, on the other hand, if they were to call and ask you, I got one question, Doc, was he facing the shooter at the time he was shot? That's something that you might be able to answer earlier.
Yes.
All right. I would not expect you to independently remember whether or not on any particular case you got any calls from a particular law enforcement officer to ask such an inquiry. Is that a fair assumption?
On an individual case, it would probably be difficult to remember every conversation of that type. Yes.
Okay. And the scalp wound that you told us about is the type of wound that you said is consistent with somebody falling and striking a hard surface,
Yes.
like a tile floor.
Yes.
Okay. So let me see, using this anatomical dial, if I can for a moment, I want to ask you about the leg wound. May I approach Dr. Vega, Judge?
Yes.
So while I was impressed with how easily you were able to put your leg up on the bar, using this anatomical dial, if the individual that was shot was falling backwards and their legs went up in the air like this, as they went back, would the trajectory of that leg wound be consistent with a shot to the leg that would go on the inside of the calf and exit on the knee?
If the leg were raised above the plane of the body while the body was falling, there's probably a location at which that angle could be produced. And I want to make sure I got the right predicate here, if you will. You're sort of assuming from the same position that the initial shot to the chest would have been fired. Is that accurate to say?
Well, again, like you, I can't say what the order was, but if there was a loss of consciousness and incapacitation and the individual were to start falling backwards, at
That's
some
one
point
theory,
in time, would
for
the
sure.
leg not be up, where it would be consistent with that angle?
In addition to the body falling backward, the hip would have to be flexed and the leg would have to be brought in front of the rest of the body. If that were to happen, then yes, that angle could be produced.
The last question I have for you, Dr. Vega, is I want to ask you about the study of wounds. As a medical examiner, you're constantly called upon to examine various wounds and extrapolate how they were incurred, correct?
Yes.
All right. And that is, correct me if I'm wrong, a science in and of itself, is it not?
I mean, it's a field of study, so I suppose the term science is appropriate. Yeah.
So we have, for example, crime scene people who study wound ballistics and the interaction between a projectile moving at a high rate of speed and human
He's doing well for
tissue
this
and
cross-examination.
skin. Those are some of the things that you're called upon to interpret as well.
Yes.
Okay.
Yeah.
Give me just a moment, Your Honor.
I buy
Of
it.
course.
It's definitely a possibility that those wounds could totally be explained. It seems more likely for the wounds to be explained from the way that this defense attorney is explaining it, rather than like the defendant is like on the ground and like shooting at his legs. That doesn't really, I don't see how that is likely. So the defense theory seems to me personally, it strikes me as more commonsensical. What do you think, Kurt?
I certainly like the questions. I haven't been catching as much as you as, so I don't have as much baseline reference.
Last
But
question,
the
Dr.
questions
Baker.
seem sharp.
Back to our
Yeah.
scenario of the shot to the leg. Hypothetically, if somebody were to throw a karate kick with their leg or an attempt to kick, might that also be consistent with the trajectory of the wound to the leg?
It would have to be a unique kind of kick to, from the front in a standing position, be able to expose the back of the leg. But I suppose it is possible if the leg were raised high enough that the back of it were exposed to the person who's facing that individual, that it could happen.
Thank you. Nothing further, Your Honor.
Yes, sir.
And yes, that is an
Any
IKEA doll.
redirect?
I recognize it.
All right. Can this witness be released?
Yes.
Yes, sir.
All right. Do you also have him under subpoena? Do you going to need him back?
Uh,
Usually when I say released, I mean the witness can go.
Yeah,
So-
we do not have Dr. Vega under subpoena.
All right, sir, you're released from your subpoena. Thank you very much.
Thank you, Your Honor.
Is that yours or is that our clicker?
That's your clicker.
Okay,
Yes.
thank you.
Interesting. Let me get some questions here. Sarah V, why do they keep calling it a projectile? It's a bullet, right? So
All right. Yes, ma'am, go ahead.
We have another witness that is fairly quick, or we can break.
I would just keep going through, but I'm known to do that and it's not well received. So how long do you think? I mean, I know for your direct, but I don't know how long the cross is going to be. So who is it?
It's a unit manager, the crime scene tech, Rich Talbot.
Oh, Mr.
And it's
Talbot.
just as to the stippling or lack thereof on the shirt. I have about 6 pictures.
I think we can do that.
All right. Miss Sarah, can we do one more?
Yes, sir.
Do you need to stretch for a minute?
No.
Okay.
Thank you.
all
All
right.
right. Let's get this witness done, then we'll take a lunch break.
Thank you. I'm
Nice
gonna
of
stay
us,
with
nice of
Rich
us to ask his clerk
Yeah.
or the recorder if they have a problem with that.
Yeah. So we've got another
But who
witness
actually
coming up.
thinks about other people in the room? Wow.
Yeah, no, he definitely seems very considerate. So why do they keep calling it a projectile? Because a projectile it can be a bullet. That's a type of projectile, but projectiles can also include shotgun pellets and things like that. Like, watching the Menendez trial, there are no bullets involved in the Menendez trial, but they're all shotgun pellets.
Do
So
you
that-
solemnly swear or affirm that the
It's an item
testimony
that has
shall
gone
give in
through
this
the
case
body.
be the truth, the whole truth, and nothing but the truth?
So it's just the technical term for it.
I don't mean to put you on the spot. Any issues with education, training, experience?
Maybe.
Okay, so let's go ahead and put that all on. Go ahead, ma'am. Sir, as the deputy said, 12 to 15 inches from the microphone, loud.
Just
clear
trying to
voice
save
should be
time. It's like,
fine.
can we
If you
stipulate
need to
the
adjust it,
expertise?
Please feel free to do
Yeah.
so.
Okay, thank you.
Good afternoon.
Hello.
Please state your full name and spell your last name for the record.
Rich Talbot, Talbot,
And by whom are you employed?
Manatee County Sheriff's Office,
How long have you been so employed?
for about 23 and a half years.
And what are your duties with the sheriff's office?
I'm in charge of the crime scene unit, so I run the day-to-day operations of the unit. And that can entail anything from assigning and reviewing cases to responding out to a crime scene. I'm responsible for supervisory type issues. And then sometimes I also do crime scene processing as well if they need it.
So sometimes you function as a crime scene tech.
Yes.
And how long, your whole 23 and a half years, has that been as a crime scene tech or there in the manager
Yes, I spent 2.5 years as a regular technician and I was promoted to supervisor.
And during the whole 20 plus years after becoming supervisor, you've continued to work as a crime scene tech?
Yes.
And can you tell me a little bit about your education to become a crime scene tech?
Yes, I have a degree in criminology, a bachelor's degree in criminology, and once I got hired here at the sheriff's office,
Can you hold down the fort real
they
quick?
have sent
I
me
can.
to,
Okay,
I have
I'll be
about
back in
300 to
like 5 minutes.
400 to almost maybe
Okay.
500 hours of job-specific related training courses.
It's just you and
has
me
that
now,
continued
chat.
throughout your time at the sheriff's office?
How y'all doing? Uh-oh. She hit the pause button. Lita?
Even more recently
no.
when you've
Thank
been
you.
functioning as a manager?
Yes, a lot of the time was in the first probably 10 to 15 years that I was here, and then, but our training goes more towards the newer technicians now, and now it's more supervisory type classes that I attend.
Yes, sir. And has your training included using an infrared camera?
Yes, I attended a training class for that.
And what is an infrared camera?
An infrared camera allows you to actually create a contrast between the surface that you're looking at, the item, may it be clothing or skin, and it creates a contrast and it takes some of the colors out of the item you're looking at, and the substance that may be on the clothing or on the skin, it enhances that.
And that's a type of camera the sheriff's office possesses?
Yes, we do have one.
And you have used it regularly over the years for testing?
Yes.
And do you have to use an alternate light source? That's a mouthful for me, I'm sorry. To take the photos, or is it something that the camera does itself?
No, the camera actually, there's filters put on the end of the camera lens, and we hold a small infrared flashlight that actually you shine on the surface of the object that you're looking at, and then the camera takes the picture.
I see. So we'll come back to that, but I want to take you back to September 27th of 2020. Were you working that day or on call at least?
On call.
And did you respond to a scene at 11331 White Rock Terrace?
Yes, I did.
And was that as a supervisor?
Yes.
But while there, did you assist crime scene tech Amanda Conlin in some of her scene processing?
Yes, I did.
And did that include the trajectory rods?
Yes.
And so on that date, were you present the entire time Ms. Conlin was there processing the scene and learning along with her?
Yes, I was.
Thank you. Did you at some point a couple days later return to the scene to do some additional work?
Yes, we did.
And what was that for?
That was to go out and complete a scanning of the crime scene utilizing a ferro terrestrial laser scanner.
And was that completed by yourself or another crime scene tech while you were there?
The main person completing that was CST Rudolph.
On about a week later, I guess, on the 6th of October, were you asked to actually process some items in the lab?
Yes, I was.
And what were you asked, or what did you assign yourself to process?
Essentially, there was a shirt that the victim in this case was wearing at the time of the incident, and I was asked to examine that shirt for any gunpowder residue or anything like that, stippling.
And what is stippling? And let me ask you this.
Question.
Through your time as a crime scene tech and the unit manager, have you dealt with a lot of gunshot cases?
Yes, we have.
And have you received training and experience in things such as soot and stippling?
Yes, the training and experience is a lot of different cases that have involved that.
Yes, sir. Okay, so what is stippling?
Stippling is small particles that are that come out of the end of the barrel of the gun, from the ammunition, and depending on the range of the gunshot, the firearm from the surface of whatever it's striking, it's basically small particles that will show a pattern or of burn marks or little particles that are land on that surface.
Because correct me if I'm wrong, when a gun is fired, I call it a bullet, but the projectile leaves the end of the barrel.
That's correct.
And with it, gunpowder, which has made it go bang, might also exit.
Yes.
And is it your understanding from your training and experience that at certain distances, that gunpowder could land on a victim or clothing on the victim and leave some residue?
Yes.
It's a bit leading, so.
Okay. And so what is soot?
Soot is just a
Powder.
like a burn mark or something like that the powder is leaving on the skin or the clothing or stuff like that.
And would that be the same where the powder, just expand a little bit on the powder from?
The firearm
Thank you.
or from the ammunition.
Thank you, sir. And did you in fact process the victim's shirt in this case?
I did.
And did you document using a regular camera and or an IR camera?
Yes, both. We took photographs of the shirt with a regular camera, and then using the infrared camera, we took photographs of it.
And could you explain a little bit more about the process? You said there's different filters. Could you just explain so that we can understand exactly what that means?
Yeah, there's the camera kit that the IR camera uses comes with 3 different filters, I believe, and there's different levels of the light, the amount of light that it allows in from the infrared flashlight. So there's different levels of the filters that will allow it to see different light.
And based on the different levels of light and the different filters, what occurs to the item you're examining?
Depending on the filters, the more light that lets in, it just the more the the filter will allow more light in, and like the shirt, you're looking at a shirt in this case, the colored background will fade away more using the different filters. You have different levels of the background that's taken out. And then the substance that's left on the shirt will absorb the light, and basically it creates more of a contrast between the substance that's on the shirt and the background color of the shirt.
And Mr. Talbot, I'm going to show you 39 through 43 was been pre-marked as state's exhibits. Would you take a look at those pictures and tell me if you recognize them? I said, I don't know. It's 39 through 44. I may have misspoke. I'm not sure if I said 43 or 44.
Yes, I recognize them.
And how do you recognize them?
They're the photographs that I took on the shirt that day.
And do they appear to fairly and accurately depict the examination you performed on October 6th of 2020?
Yes.
Your Honor, at this time, the state would ask to move in states 39 through 44.
Any objection? Received?
And may I publish them?
Yes.
Thank you. Mr. Talbot, there's a laser pointer there if you need it. And
Thank you.
I'm going to steal it.
Mm-hmm.
I'm showing you what's this is states 39. Can you just kind of describe for the record what we see here?
This is just an overall of the shirt on the front side of the shirt. As we put it back together a little bit as much as we could, you can see the cut marks in the shirt where EMS cut the shirt off the victim.
So it's kind of a cross in the middle, and that's your understanding that's from EMS.
Yes, that's what I believe to be.
Thank you. And then what's the area of interest on this shirt?
This right here is the gunshot hole in the front of the shirt. I placed a white card in behind that to be able to see the hole.
And I'm going to show you states 40. There was only one. How many holes did you find in this shirt?
Just one.
Okay. And so this is the same one we just saw in states 39?
That's correct.
Okay. And you said you placed a white card behind it?
Yes.
Okay. And so these two pictures that we've just seen, are those through a regular camera at regular light or not?
Yes, I believe they were.
Okay. And then after taking photos at regular light with a regular camera, what do you then do?
I then start using the infrared camera and
Yeah,
just take
that
some
shirt
more
is
of the
definitely
same
a workout
series of
shirt.
photographs,
All
but
reps
not
matter.
without the overall in it.
Yeah.
And
I
during
want that
the
in my-
course of
I
that
want that in
taking,
my
are you
life.
changing those filters you told us about?
Yes,
I've been going to
I
the gym a
changed
lot
the filters
lately.
as I went through, going through
Yeah?
each
Putting it
level
on my
of the
community
filter
tab.
to see
Good.
what is going to show
Oh,
the
yeah,
best
I've seen a couple of
contrast.
those posts.
And
Yeah.
That's awesome.
I believe states
Keep it up.
41 through 44 is a sampling of those photos. Is that correct?
That's correct.
Okay, thank you. I'm going to show you states 41. Do you, ultimately, when you're using this infrared camera,
So that's
if there were
the gunshot
stippling
from
and
the
soot,
side
what would you
slash
expect to
front.
see?
I would expect to see the background colors of the shirt to lighten quite a bit, like where you see this dark right there and it's gray.
All
It
reps matter, but do
lightens
all
up
sets matter?
significantly. And if there was stippling present, you would see darker particles or powder burns around the bullet hole.
Rep, short
And in
for
states
repetitions,
41,
right?
do you see any
Mhm.
of those darker
trying to
particles
think, yeah.
or
Yeah, yeah.
bullet or burn marks?
No, I did not.
I'm going to show you states 42. It looks somewhat different than 41.
Yeah, the
And
media
what accounts
reporting
for
on
that?
this aspect is dead wrong.
It's just a different.
The media
said
being dead wrong on a
different
case?
filter.
No.
And the
Never, right?
background on the dark,
Such a
the
novel
darker
thing.
area is lighter color now. And
I was
the
reacting to
gray
a
shirt is lighter color
Vanity
even more
Fair
to it,
article
where
today
it's
where they
almost
were
like
moaning
it's
at
a
the
whitish
Supreme
color.
Court and just beating them
And
to
did you
death.
see
That was fun.
anything under this filter that indicated to you there was stippling or soot?
No, I did not.
And I'll show you states 43. Again, it looks a little different.
Yeah, and it is just another filter we used. And again, there was no other areas of stippling that we thought that could be there.
And then finally, states,
I'm also going to start making fun
44.
of your brother, Alita, for not working out as much as
again,
me.
a little different.
Now more
Just a
buff
different
than
filter
him.
again.
Bring it.
It may be the different filter,
Fair.
but it's also
Do
a
it.
closer up shot,
Andy is slacking.
showing the bullet hole a little bit closer.
And now we see some faded portion there around the bullet hole. What is that? Is that attributed to anything?
In my opinion, it was attributed to just wear and tear of the color of the whatever that the color of the shirt is, and because you can see the wear and tear in another location of the shirt showing the same thing.
And was that location close to the bullet hole or somewhat at a distance?
Further away.
So after conducting this examination of the shirt using your
Are you still
infrared
doing your runs
light,
for your
did you
subscriber
find
count?
anything that indicated to you there was soot
I
or
have
stippling on this shirt?
put a temporary
No, I did
hold on
not.
that, but it's one of those
Can I
that
have just a moment,
I
Judge?
need to do. I definitely need to do.
Where'd you stop at? 30?
Where did I stop? No, it was a lot earlier than that.
Okay.
Yeah. I
So you
know.
owe them like 100,000 kilometers cumulative. At this
I was
point?
only going to go up to 50. I made
Yeah,
the
well,
promise.
yeah,
up to
yeah, but you're
50K.
doing what, every 10,000?
Through your time
Yes,
as a
I
crime
think
scene
so.
tech
I have
and
to
subsequently the
back.
manager, have you been
Yeah, so
trained
50
on
plus 40,
or come to know through
90
your
plus
experience
30,
generally
120.
how far
So-
soot it
Yeah.
or stippling
Better get those
exits
120,000
or how
kilometers
how
in.
far away the gun would be?
I know. It's a lot.
I couldn't give you an expert answer on that question, but through my
She's running around
experience
the world.
with the
The
medical
whole world.
examiners and some different firearms experts, I've heard that it's outside of 3 feet, inside of 3 feet, you can start to see some of that stippling and gunpowder maybe. So that's just the general thing that I've come up with that I've known over the years to be at
Okay,
outside.
so what
of
does the
3 feet.
stippling tell us
Thank
about
you,
the
sir.
distance?
I don't have any further questions, Judge.
Oh, did they say how close the gun was
do you
to the
want any
body
of
based on
this,
the
or-
stippling?
No, but I mean, stippling implies the gun's going to be pretty close. It's going to be within
Do you,
Absolutely.
like 2 feet, I think.
No, I was just
So
saying.
did he say
were you
that
gonna
he
use
didn't
the
find
display?
stippling,
All right.
or
Yes,
that he
sir.
did? Because I remember the other thing that the media said was that there was a suggestion that she was far away from him. So he would have to say that
Afternoon, is
there's
it
no stippling on the body.
Deputy or Mr. Talbot?
Mr., if you wish, that's fine.
Civilian.
Yes.
All right. So, Mr. Talbot, you've told us that you examined the shirt. It had no signs of stippling.
That's
No
correct.
signs of stippling.
And
Okay.
stippling being the gunpowder residue that comes out the barrel of a gun when it's fired.
Yes, the small particles that will come out of the gunpowder. And
A lot of times it leaves like tattooing when it's in close range.
that's correct.
All right. And you've told us that stippling generally travels, I believe your words were outside of 3 feet.
Yeah, the distance, if you're expecting it to show up on the skin or the shirt or something like that, they would expect it to be somewhere around 3 feet. You'd expect us to see it there.
Okay. So would it be fair to say that what you're telling us by your testimony is that making believe that you are the shooter and I am an assailant, and I have previously on this occasion assaulted you, and now I am coming at you again to assault you. You're telling us that you shot me, and when you shot me, I was 4 feet or more away from you.
Potentially.
Yeah. That
This doesn't sound
you
right.
chose not to let me get closer than that to assault you a second time.
Yeah, it doesn't sound right.
Potentially,
If you're more than
That's
4 feet away, you shouldn't see stippling because the stippling is very
Can you read
fine
the record?
particles. It's going
All
to
right. Can this
dissipate
witness
into
be
the air
released?
pretty rapidly.
Yes, sir.
All right, sir, you're
So,
releasing your
yeah,
statement.
well,
Thank you
so
very
he
much.
didn't see stippling, but the way he said it, it almost sounded backwards. Maybe it was
All
just my
right.
ear playing tricks
Let's
on me.
take a break.
Could be.
And it's just a little bit before 1. I think we can be back by 2. It's a little bit after the lunch rush, so hopefully
Yeah.
everybody can get in and get out. Does that sound all right?
I've seen so many of these trials at this
Sound
point.
okay?
I'm an expert in this stuff
All
at this
right.
point. You just call me the stand. I know the
The only
answers.
thing I'll say is, folks, obviously, when you step out of these doors, I don't have any jurisdiction out there, but I'm going to ask that both sides just kind of go your own way, have your lunch, be back by 2 o'clock. We don't
Have
need
a
any-
brawl in the
any
parking lot.
difficulties.
Solve this like men.
Yes, the doors will be locked. Absolutely.
Let's have a last minute settlement.
Sure. Thank you so
So,
much.
okay.
You're always a trooper. I appreciate it.
So now we've got a break. We'll just put this to live. So what we're going to do is we're going to talk for a little bit and then we're going to, oh, whoops, I did not mean to pause it. We're going to talk for a little bit and then I'm going to take a break and we'll do a separate live stream for the afternoon session. So why do you keep pausing this? Okay. So that's what we'll do, but we'll talk for a little bit first though, on this. So the whole bit about him getting shot in the back, wrong. Medical examiner did not testify to that as well, or at all, I should say. This might look better for the defendant than what was reported. So interesting stuff. Let me get some questions here. And sorry that my feed is a little bit slow. There's a delay with the visual of me, so I might not be in sync with my visual and audio performance here. Debbie Faison Cook says self-defense is using just enough force until you're out of danger, correct? It doesn't mean that it's okay to kill someone. I mean, if he's down, you can't keep shooting. Well, so true, but also not quite so true because you are supposed to be able to use the amount of force that is reasonable. If somebody, let's say you've got a bar fight between two guys, one guy punches the other guy in the face, the other guy pulls out a gun and shoots him. That's not reasonable, right? That's way more force than what was present by the other person in that situation. I could see a situation where a gun could be usable under a self-defense by someone who is in a much more vulnerable situation, who is physically much smaller than the other person. I could I could see circumstances like that existing but, you know, as a default matter, when we are talking about there's only one firearm present and the firearm is being held by the person that killed the other person, you know, the person that died didn't have a firearm on them. Those are some very big questions that have to be answered by the defendant. And for exactly that reason, you know, right? Because the amount of force has to be reasonable. Now, as it comes to the timing, in these kinds of situations, it's really difficult for someone in the moment to stop shooting, right? So if once one bullet has gone, it's really hard to say to like hold a standard to say, you know, oh, well, one is enough. Two is not is too much. Three is too much, especially if they are in rapid succession. Like if they're all part of the same moment, these things happen very, very, very quickly. So you have to consider them all part of the same encounter. But if there's a situation where somebody shoots once, they run away, hide, and then there's a second encounter, they shoot again, then we can start counting bullets. So it's entirely dependent on the circumstances there. Gwendolyn SS, back of the leg, trying to keep him from walking away. I think, you know, another thing about these cases that involve firearms is it is really, really hard to aim these weapons. Like even if you are a sharpshooter on a firing range, you are very well practiced with your firearm, especially when it comes to a high stress situation and someone is you know, you feel threatened by someone or you have an elevated heart rate for whatever reason, your aim can be entirely off for a number of reasons. So, you know, to say like, you know, aiming these things at somebody's leg is really, really hard to do and to hit exactly where you want it to hit. I can't say from personal experience on that because I've never been in a stressful situation with a firearm, but yeah.
I'm a NRA basic pistol instructor, and I've never known any instructor at any level to be like, in the event of a self-defense situation, shoot for the arm, shoot for the leg. That's a fantasy. Like politicians who say that don't know the first thing about what they're talking about, especially in any sort of dynamic situation where people are moving around and you're trying to hit a small moving target under stress with adrenaline, and you've got issues with sight preclusion, audio preclusion, because you get tunnel vision and you get audio tunnel vision, same thing. Like you're stressed, any sort of ability to your fine motor skills go to shit under stress, and shooting is a lot of fine motor skills, as you would appreciate. So I don't know any instructor who would be like, oh yeah, shoot for the arm, shoot for the leg. It's always shoot for center mass.
Yeah.
It's the biggest thing. It's the biggest thing. Plus you want to stop the threat, and shooting the center mass is most likely to stop the threat.
Yes.
And if you're you don't shoot to warn. So actually, even if you could, in principle, shoot the leg or arm, like it would almost by necessity be illegal, because you only shoot because your life is in danger. It's like if you're shooting the leg to you know, try to like, it's like because you don't perceive the threat enough. It's almost counterproductive to a self-defense claim. So I don't know any person who would recommend it practically or legally. So don't do that.
Yeah. Yeah. And obviously none of this is to be taken as legal advice, as we always want to say, you know, we always want to clarify that in either event. Right. Now there's also, it's been mentioned his military history. We heard from his cousin a little bit about a military history, that he has some military training. I think he was in the Navy, but I don't know how many years he actually spent in the military, or you know, if he had any sort of specialized training. I would say that the fact that he was in the military means that he has some experience with firearms. It doesn't necessarily mean that he has extensive experience with firearms or hand-to-hand combat or things like of that nature. Like he's not, you know, some like human body weapon, you know, just by virtue of him having served in the military. So, you know, his experience with martial arts, yeah, maybe, I don't know. Like the fact that he has done martial arts or CrossFit or these other things would likely mean that he was probably in pretty good shape, but it doesn't mean that he's an expert in these things. Like, right. Like he's not, we can't assume that he's a Jackie Chan because of that. So, and then there are a couple other questions here, and then we'll probably take a break. Gwendolyn SS, but does that excuse her actions? Make the stand your ground plausible? So in terms of, I think this was in response to getting maybe the angle of the gunshots, perhaps. I don't know. I mean, at this point, I feel very much like this question of whether or not she used self-defense is a gray area, which to me means it goes to trial. Judges, if there's any sort of gray area, judges don't like to take it away from a jury. They much prefer for a jury to make that determination. Even with the state having the burden in this hearing, like I said, it's a lower burden than at trial. So, yeah, I don't know. We haven't heard all the evidence. Definitely going to be waiting to hear the rest of it for sure. But my opinion has changed back and forth several times so far based on the evidence. Like I started off hearing what the media was saying about this case and being like, oh, I mean, if she shot him in the back 4 times, then that sounds it's pretty tough. She's got an uphill battle here. But there's still questions about her allegation about the heavy metal poisoning. But he also is not a perfect person either, because it seems to be, that he had some anger issues, that he punched a wall. He shot a gun at the ceiling at one point during their relationship. So it's like, this is not a black and white situation at all. And then also from Scott J, is a stand your ground hearing an automatic thing, or does the defense have to proactively ask for this hearing? They have to ask for it. And they filed a very hefty motion. The judge, towards the beginning of this hearing, he kind of like showed a lot of the paper. He was like, this isn't even everything, but this is what you guys filed. And I read it all. So they have to request it in order to have this kind of a hearing ahead of the trial. So yeah, so that's what I got for this one. Kurt, do you have any other thoughts on this?
No, it sounds all about right. No, generally agree. I think I would share the general skepticism at the court granting the motions. I think, judges are pretty reluctant to grant them even in Florida. And I think Steve Gosney has talked about the fact that a lot of defense lawyers waive them for the same reason they waive preliminary hearings. Like, you don't want to give the state an ability to practice, and find errors in their own presentation. And you don't necessarily, you don't want to tip them off as to your own strategy. You can probably avoid the second about tipping them off about your own strategy, but it's like every time you give the state a chance to present its case and present its witnesses, if that answer wasn't perfect, they can work on correcting it. And so you give them multiple tries to get it right. So it comes with consequences. So I know a lot of defense lawyers don't like them for that reason.
Yeah. I mean, it basically is it's a mini trial. Like I said at the beginning of the stream, it's a mini trial here, which gives both sides the opportunity to put on their best arguments in front of the judge, test them out, see what works and what doesn't, also to see a little bit of what the other side's got. Which, I mean, both sides, there are advantages and disadvantages to doing that. But it'll be interesting to see what happens with this. So, all right, well, cool. On that note, so what we're going to do is we're going to end the stream, and then it should be, I think he said 2 p.m. East Coast time is when they're going to get back from lunch. So I'm going to set up another stream. If folks are watching on replay, I will put it in the pinned comment on this stream. I'll put the link to the new one. And I think that's about it. So if you guys want to join, continue watching this hearing, I'm finding it very fascinating. And Kurt, you are more than welcome to join me as well in the afternoon session too.
Yeah, it might be a little bit later. I think I'm going to try to get some food and hit the gym before then, but I might hit you up a little bit later this afternoon, but it sounds fun.
Sure. Sounds good. All righty. And with that, Okay. So yeah, I'll see you guys. I'll see you guys in like 45 minutes. Keep an eye out for a link to the next one. And yeah, I will see you guys in the next video.